reacting to COVID, but it's nice to see everyone's face and certainly some friendly faces that I know. I love to hang out with the pro management side people. It's been a passion of mine to be in this side of the business for 30 plus years now. Seems like forever. I never thought I would be practicing labor and employment law for 30 years. But what a wonderful thing to do, and I've really enjoyed meeting so many great people and friendly faces. For those of you who don't know me, my name is Steve Gutierrez. I am based here in the Denver office as a labor and employment practitioner for my entire career. So I've had a lot of experience in a lot of things, but what I'm going to tell you is, we are in a transition period in Colorado. And we're going to talk a little bit about that transition. Probably not surprising with the demographic changes in Colorado. I'm a Colorado native, and so I've seen the remarkable change of this city and the population density change. And with that, it has changed our political structure and how we lean, I think, maybe more or pro-employee today, whereas 20 plus years ago it was pro-management and pro-business. So we've seen a lot of those changes here in Colorado. We're going to talk about a few of them. All of us, my colleagues, would love questions, real life examples that we could work through to the extent we can in this open forum are welcome, because I think you all learn from each other's experience. Certainly that's the way we learn as lawyers. In your packet, a couple things. You'll get the written material. Certainly if you need something electronic, our team can get that to you if you want that. Our Wi-Fi address and password are here at the bottom of the screen, so it should be on the first page of your packet. I know that's important. Feel free to continue to graze if you need to get something to eat or a cup of coffee. It's not going to interrupt us at all. But let's talk a little bit about what we're going to talk about today. But initially, for those of you who have not signed up for Holland and Hart's labor and employment blog, you can do that. We post fairly frequently. It's not on any real cycle, but the posts are done by all of us within the department. Sometimes we bring in some of our colleagues from our regional offices who maybe do a specific article on a federal issue. And so they may not be based in Colorado, but it's a great resource in addition to probably the other resources you have. So feel free to do that. Certainly you can sign up for alerts, et cetera. Some of that information will be provided in your materials. We always do our little disclaimer here because, though many of you are clients, we're not here to, give you specific legal advice on issues without consulting directly. So that's our risk management people. So I got to give a nod to them. For the agenda today, David and I, David Law, who I'll let introduce himself, will be talking about the hot topics in Colorado, specifically the Healthy Families and Workplace Act, some issues with respect to layoffs, which may be, with a recession on the horizon, maybe something employers will start to think about more. We'll talk a little bit about some modifications to the Colorado Anti-Discrimination Act and some trends in federal law in the discrimination context. And then we'll conclude this morning session, which will end roughly 9:45 for our first break, by covering some wage and hour issues. There's some big changes on the horizon, have been some big changes in Colorado. So we'll chat about that. Then later, we'll do an in-depth session on Colorado's new non-compete statute and some trends in non-compete enforcement, and then end with pay equity, which continues to be one of the hot topics that many of you guys call us about and have been calling us about since that's passed here in Colorado. So with that, I'm going to let David Law take the podium and introduce himself.
Thank you, Steve. Hi, everyone. It's nice to be here this morning with all of you, and glad that we're all here today to talk about these exciting developments. Lots going on in labor and employment law in Colorado. I'm sure all of you already know about the Healthy Families and Workplaces Act. It's been around for a few years. Today, we're going to cover some of the updates to the law, some recent interpretive guidance that's been issued by the CDLE, and a recent decision that was issued by the Colorado Department of Labor and Employment to Southwest Airlines that highlights some of the key areas that employers need to be aware of when they're implementing these policies around sick leave. So just a quick refresher, HFWA leave is paid sick leave. It's 1 hour for every 30 hours work. So that's what the law requires. Many employers prefer a front-loaded approach on which employees receive their full allotment of paid sick leave at the beginning of the year or on their first date of employment, whichever comes first. You have to provide at least 48 hours of leave per year, assuming that they're full-time employees. They're working 40 hours a week the whole year. Obviously, it's subject to that 1 hour per 30-hour accrual rate, but generally speaking, if it's a full-time regular employee, 48 hours a year is what's going to apply. Important to keep in mind that it does not just cover employee illness, it also covers general health conditions, really anything related to the employee's health or the employee's family's members' health. Also covers other safety and health related issues. So the law is very, very broad, something to keep in mind. PHEL, as we call it for short, Public Health Emergency Leave, is a supplement. It is, it's paid sick leave, but it's not paid sick leave. It's sort of a, I guess you call it a supplement to paid sick leave. It's 80 hours upon the declaration of a public health emergency, or if the employee is hired during a current public health emergency, they get at least 80 hours available to them to take off for COVID-related reasons on their date of hire. That 80 hours can include whatever the employee has available for paid sick leave. So, for example, if an employee has the full 48 hours available on January 1st, the employer is only going to be required to ensure that they have 32 hours of PHEL available to make up for that difference. The employee is then going to have a total of 80 hours available. So if they get COVID or if a family member gets COVID, one of the reasons it's covered under public health emergency leave, they'll be able to take off 2 full work weeks if necessary. As we'll talk about, there's some sort of wrinkles in terms of reconciling the PHEL requirement with the paid sick leave requirements, but those are sort of the general requirements there. And just to note, the current public health emergency is still in effect through November 10th. If any of you are curious on that or would like updates over time, you can always just go to the CDLE's website and they do update it pretty frequently.
Yeah, I think the governor's been pretty fair, progressive comparative to other folks. My guess is that public health emergency will stay in effect through the winter months, just because, with guidance, we suspect that there'll be spikes in COVID again. It's getting a little more tenuous to maintain a public health emergency, given sort of the relaxation of other rules that relate to COVID. Obviously, I think we all accept that COVID's here to stay, but expect that to be in place through the winter. And then my guess is some codification of this might be in the cards for the state, since we've been dealing with this statute for a while anyway, that there will be some sort of supplemental requirement considered by the state legislature.
Tell me again the website where they update it.
CDLE.gov.
Oh, okay.
Yeah, and I don't know the exact web page. I know it's on there somewhere.
Okay.
Honestly, generally, if you just Google public health emergency Colorado, is one of the ways that I found it in the past, but always make sure that it's from the CDLE.gov's website just so that it's the right date.
Yeah, and incidentally, they have been doing way more robust updates on the DOL website than ever before in the last 4 years. So there's guidance on almost every component of Colorado law that it's worth having that marked on your browser.
It's a huge resource, definitely. Yeah, thank you, Steve. That actually reminds me. There's something on the website about monkeypox. I haven't really been following that, and I'm not sure if it's still an issue as much as it was several months ago, but I know that was, I believe, a public health emergency was declared for that. PHEL is not currently required for that. It could, in theory, as Steve mentioned, be, in the future available for other types of public health emergencies, but as of right now, it's just for COVID. Okay, so again, PSL paid sick leave is very broad, covers a lot of different health-related issues and safety-related issues. Some open questions, or I guess a open question is whether pregnancy is covered under it. We ran into that issue several months ago, and it's sort of an interesting question. Perhaps it's a, pregnancy or a birth of a child, any sort of health condition related to that, whether it's recovery or perhaps a complication. If it's a complication, it would almost certainly be covered. If it's just regular uncomplicated pregnancy, then there's arguments on both sides. Anyway, so just being aware, I guess, of some of the areas of the law that are open to interpretation. It's very employee friendly and very hard on employers. There are lots of loopholes and requirements and limits on employers, not nearly as many on employees. Very lax documentation requirements when you actually look at them at what is actually required or what the employer can ask for. Stringent posting and notice requirements, as we will see. And again, just some of the hot issues, timing and use of PHEL, public health emergency leave, single PTO, PSL policies is a big one that we've run into a lot. The law does provide that you can use a single policy for both PTO and paid sick leave. However, as we'll see, that can present some issues. Notice requirements, and then lastly, there's a provision in the law that provides that an employee can demand unpaid paid sick leave if it's not given to them, and it actually cites to the Colorado Wage Act for that, and perhaps integrates some of those standards that could apply there. So just to kind of guess sort of a general timeline here of public health emergency leave, we had some updates at the beginning of August, CDLE updates to Info 6B. It's not binding law, but it's still very informative, and it tells us where the CDLE's enforcement priorities are. It's important to note, one of the things that they said in that update is that this 80 hours of PHEL is provided at the time of the request. Without going too far into detail on why that matters right now, the long and the short of it is that it helps avoid some of the complications that can arise as far as offsetting the employee's then available paid sick leave against the employer's 80-hour obligation. So bottom line is just focus on, I guess, if you focus just on paid sick leave, making sure that you cover the requirements there, and that, if PHEL is requested, if a COVID-related issue comes up, that 80 hours is available, that will satisfy the employer's obligations.
Here's a question.
Question for you.
Yeah.
So the 80 hours, though, that's a one-time distribution, correct? At the time of the initial COVID, everyone got 80 hours. If you used your 80 hours in 2021, you get COVID today, there isn't anything left.
That is correct.
So
Yes.
then, because we've been dealing with this, so then people, some employees don't want to use their PTO.
Right.
And so I don't know, do they have that right to say that they don't want to use their PTO? If the policy says we go with PTO, then extended leave, and then.
That's a good question, and I wouldn't be able to advise specifically on it without looking at the policy and the situation. But I would just say, generally speaking, because this is a statutory entitlement, it says these aren't things that are merely available to employees, but these are guaranteed to employees as a matter of law. I would say that if there was a choice between PTO and paid sick leave, then the employer would have to allow the employee to use paid sick leave if it was available. And that having a policy in the handbook, similar to a policy that you might have for PTO and FMLA sort of thing, where you have to exhaust your PTO first before you can go on FMLA, I don't believe that would be permissible. But again, I would have to, I guess, look at the specific situation to tell for sure.
So if employees challenge, because I'm getting challenged on, no, we get 80 hours every year. It's like,
No,
no,
that's
you
wrong.
don't.
That one's easy. But,
Yeah, I know.
yeah. Some of the other ones are not so much.
And 80 hours is for full-time employees, correct? Is it 40 for PT?
That is a great question. I believe it's for all employees. I think it's just for everybody, actually.
Yeah.
Okay, because last
Back
year
in
on the
the statute.
CDC, it said that it was half for part-time employees, but I don't know if
Really?
that's changed since.
As I recall, and again, I'd have to look at I have the statute saved because I'm pulling it up constantly to read through all the provisions.
Yeah.
But as I remember it, it is 80 hours for all employees. I
Okay.
think the paid sick leave is what varies between part-time and full-time employees.
Okay, thank you.
Understanding. Great questions. Anybody
I
else?
just want to clarify the 80 hours. Did that start in 2020 or 2021?
I believe it started in 2020.
20.
So if they used hours in 2020, that's the one time, or was it granted again in 21?
No,
Okay, just want to make sure.
Yeah. it's,
One time, so
one
starting in
time per-
2020, if you've used 30, whatever, 80 hours, you're done.
exactly per public health emergency.
Thank you.
Absolutely. Anybody else have questions on that? You want to be mindful of time, but I know that this is a very important area for a lot of employers. So I will also say that if any of you have questions on this or want to talk about it afterward, I'll be sticking around and happy to talk to you about this. Okay, so I am going to go a little bit faster through some of these other slides just to make sure that we can stay on pace. This is just an example of sort of the situations that can arise if an employer front loads employees with PSL and PHEL. It basically just illustrates the offsetting requirement. If any of you have questions on this or would like to actually see this example in greater depth, let me know afterwards. Flexibility and leniency, again, as a general rule, the law is very favorable to employees, not so favorable to employers. With a single PTO policy, sick leave policy, employers can get themselves into trouble, as we'll soon see, by trying to sort of apply all the same rules that would typically apply to PTO requests. In your typical PTO policy, you're going to have, provisions such as, PTO requests have to be approved ahead of time or need to be submitted in writing to the supervisor within 7 days or 14 days prior to use or something like that. And also that there's some level of discretion on the company's part in granting or denying PTO for business needs. Also perhaps a provision relating to abuse, disciplinary action if a employer believes that a employee is abusing paid leave in some way. All of those provisions could be problematic if you are using a combined paid sick leave PTO policy because of the requirements that the HFWA imposes. The law says you can use a single policy. In fact, you can call the policy whatever you want. We don't care if you called it paid time off, flexible time off, whatever you want to call it is fine. What we care about is that the leave that's available is available for everything that the HFWA covers under the same exact conditions and no additional requirements apply. Try to impose any additional requirements on an employee's use of paid sick leave under the law, then you'll run into problems. In practice, some employers have tried to get around that by saying, well, what we'll do is we'll say that if the employee is using the PTO for sick leave, we'll ask them that. We'll ask them, why are you using your PTO? If it's for sick leave, we'll apply the HFWA rules. If it's for general PTO, we'll just apply our general PTO rules. That is an option. However, at that point, you have to sort of ask yourself, have we really done anything? Are we still implementing two separate policies under the name of one policy only? Is it just easier at the end of the day to have two separate policies? Again, it's going to depend on, the individual company and its culture. There may be reasons why that would be preferable. I would just say it is something to keep in mind, some of the challenges of treating different types, or I guess the same type of leave differently based on the reason that it's being used. Anyway, moving on really quick. Just some of the notice requirements. These are some of the examples of issues that can come up. Minimum documentation requirements. Employer cannot deny requests for lack of notice. Documentation only needs to be provided when the employee returns within a reasonable time frame. Lots of options for the employee. Again, this just goes to some of the pros and cons that we were talking about as far as combined policies, and the bottom line, I mean, I'd say that the big pro is that it's of keeping them separate is that it's going to reduce the risk of HFWA noncompliance. The downside is that ultimately you may end up having to pay out more leave because you're not able to benefit from putting everything in the same bucket. Okay, so CDLE versus Southwest Airlines is a recent administrative decision that was issued by the Department of Labor back in the spring. It was in the news some. It was a pretty big decision. It's currently on appeal. As of a few days ago, I don't think that appeal has been decided yet, but that may change soon. CDLE imposed $1.3 million in fines, including over $887,000 for HFWA violations. Just as a side note, Southwest is currently challenging that decision in a separate federal action, basically arguing that the HFWA is preempted by federal law and is unconstitutional. So that is pending as well. This goes to the single PTO paid sick leave issue. That's what Southwest had. They had a single policy. The first thing that the CDLE noted is that just because Southwest has a CBA, a collective bargaining agreement, does not mean that they're exempt. There's provision in the law that does exempt employers with CBAs under certain conditions. CDLE said that those conditions weren't satisfied. And those are just some of the conditions that had to be found. So multiple violations. The policy did not allow for the use of paid sick leave for the required purposes. So again, this goes back to understanding that this is not just a sick leave policy. This is a family leave policy. This is a health and safety related, issues. It covers a lot of different things. Self-inflicted illness and injuries could not be excluded. Also, this is good to note for us lawyers, unless otherwise required by applicable law language, the CDLE said that would not cut it in this instance. A lot of the times we like to include language like that in our different handbook provisions to sort of cover ourselves and say, well, to the extent that anything in here is not compliant with the law, this will cure that issue. And the CDLE said, not in this situation. The employer needs to specifically advise the employee of their rights under the HFWA. You didn't do that, so there's a problem.
So if you have a multi-state employer, and some of you are, what we've been doing is addressing the specific requirements of sick leave, by example, Colorado's specific requirements in a separate policy that this is applicable to Colorado employees. And say you're also doing business in New Mexico, you have a separate policy for New Mexico employees because the language is different in their statute. And then the catch-all for non-Colorado, non-New Mexico employees, this one applies to you. It's an odd time because obviously that creates some disparity in the benefit that you're providing to certain people, which is sort of contrary to most people's culture. At least you're trying to be equal, but it's because of this conclusion that you can't put this unless otherwise available, under the law, which I bet 95% of your policies have those catch-all languages or language in them. I go back and look at the policies just to check whether that you want to continue to use that catch-all language.
That's a great point. Thank you, Steve. Okay, and I'm going to go through some of these other slides more quickly. Are we providing copies of these materials?
Yeah.
Okay, terrific. So if any of you want to go back and look at these, you can. Again, I'll be available afterwards as well. But lots of violations, lots of issues. The bottom line with all of these is that Southwest is trying to impose requirements and restrictions that the HFWA does not allow. Something I wanted to note, poster requirements. The CDLE took special issue with this. It took issue with the position of this door here because it said that the standard is the posters have to be conspicuously placed and somewhere that is frequented by employees. the division said that because that door would open and cover up some of the posters, it didn't meet that requirement. So just sort of an interesting side note. Also, it took serious issue with the fact that some of the posters were out of date. They were a year old. They weren't even that old, but they were not quite current, and that did not cut it. Yeah, and just a side note, so even if you comply with all of your requirements under the HFWA, if your HR department or supervisor or somebody provides inaccurate information, that will negate whatever compliance measures you took in writing, at least according to the division. Again, all of this is on appeal right now, so we're hoping that some of this gets reversed, but these are just sort of, tells us where the division is currently at. And let's see. I don't think, I'm going to skip over that for now. Yeah, these are just basic notice requirements. Again, you can look at the slides in greater detail if you'd like more information on those. The bottom line is that posters are important. There needs to also be something in writing that goes out to the employees. I believe that generally happens when the employee is hired. I don't think that there's an annual requirement with that. Remember looking at that in the law, but generally speaking, in addition to whatever posters you have, it is a good idea to actually be sending something out to all of your employees saying, here are your paid sick leave rights under the law. In fact, just send them a copy of the poster. And if you send it as an email attachment, you need to explicitly say in the email, this regards important employment rights. You know, this is regarding your paid sick leave. Do not just include it as a, nondescript attachment or as something in a broader document.
And the finding that a hyperlink, I don't know how many of you use hyperlinks, if you have a lot of employees. That's an interesting perspective from the division, that the hyperlink is not sufficient. And so that you have to actually provide them the notice. Yeah. And as David said, just simply saying, hey, important information, see attached is not enough. I'm pretty surprised by that, given that, we've all become so used to the electronic access to handbooks and such. We've litigated numerous cases where the electronic trail of someone accessing the handbook, signing it through DocuSign that they received it is sufficient in and of itself, but it wouldn't be under this particular holding.
Right. Steve, how are we?
We're good on time.
Okay, good deal. So, excuse me. There was a lot to cover there, and I know I glossed over some of that. So if any of you have issues, again, please feel free to follow up afterwards. Layoffs, Federal WARN Act. This one will not be quite as long. There aren't any Colorado-specific updates for this. Colorado does not have what's known as a mini WARN Act or a law that requires advance notice of layoffs. A lot of states do. Colorado does not. That said, the Federal WARN Act does apply to certain employers in Colorado. I believe the threshold is 100 or more employees. But yeah. Okay. So it doesn't restrict employers' ability to actually perform the layoff. I think that that's an important distinction to make. It just imposes certain notice requirements. So if the employer is laying off, it's defined by plant closings and mass layoffs. We'll get to those definitions in just a moment. But the bottom line is, if either one of those is triggered under the law, you have to provide certain notice 60 days in advance. Definitions of both of those terms. As you can see, the minimum threshold for both of those is 50 employees or more. And actually under the mass layoff, there's the possibility of, let's see. No, actually, excuse me, I always get confused on these, but the bottom line is 50 employees or more is what triggers it. So if layoff is smaller than that, then you don't need to worry about the Federal WARN Act.
Do you guys have any experience with how they classify the single site? Like if you've got
Yes.
two physical addresses that are right next to each other, are those considered one?
That is a great question, actually, right here. Yes, and because I'm going to answer that right now, I will answer that by talking about this slide. And just real briefly before I do that, always remember the 90-day look-back period, which basically says that if there were other layoffs performed at I believe it is at a different single site of employment can qualify for that. If you've performed any layoffs within a 90-day period that adds up to 50 or more employees, then the federal WARN Act can be triggered. To your question, single site of employment is typically easy to determine in a traditional employment context. And this office would be a single site of employment, a traditional workplace, that sort of thing. In this day and age, though, we know that that's not as simple because a lot of folks work from home or have hybrid schedules. So 3 possibilities under the federal regulations: location to which they're assigned as their home base. That is not defined in the regulation, which is helpful. Location from which their work is assigned. That one's more straightforward. Location to which they report. Also more straightforward. So the significance, obviously, is that if you have a widely dispersed workforce throughout the United States, but they all report to the same supervisor at the same headquarters, or they all receive their work from there, or maybe that's assigned as their home base for some reason, they can be imputed to that single site for purposes of triggering the 50 employee threshold. It's an open question. There's a pending action right now in the district, Eastern District of Virginia. The court granted certification of the class action. Just to clarify, that is the court explicitly said I'm not making a decision on the merits of this right now. This strictly has to do with the requirements for getting a certification, which have to do with typicality, commonality, that sort of thing. That said, it's an open question, so we'll see what happens. And almost wrapping this up here. So going back to this remote employee question, what if the employee supervisor is also remote, which is something to think about. So that doesn't really provide us with any guidance. We don't have any idea what's going to happen with that. There is some authority out there to the effect that from the Fourth Circuit, the idea that, this law is designed to prevent certain adverse impacts on communities. And when you have a dispersed workforce and layoffs, it's not really triggering those same concerns.
I think if you remember, it only applies if you have 100 employees, and it triggers at the 50 employee threshold for the notice. But if you had a distribution center in Commerce City and you have your headquarters in Denver, is that a single site? And I think it depends on the flow of business between those 2 sites as to whether that would be considered a single site. In that, if in fact your people at your headquarters are frequently there at the distribution site and they're interacting, I think it probably is a single site, even though it may be in 2 different cities. Whereas if your distribution center's in Fort Collins and there's not as much frequency, that those are 2 separate sites under WARN. But it does require some analysis of the functional duties between the 2 sites in that example.
Yes, definitely. That was a great point. So that kind of covers the WARN Act. The bottom line, like Steve said, if it's less than 50 employees, you don't have to worry about it. Do always look at other states' requirements, though. If it's a multi-state layoff, always check to see if there's a mini WARN Act in place. Like I said, a lot of states do have those, and it's just something to keep in mind. Very last thing to cover on layoffs, a few other things that employers should look at before they're moving forward. Something called OWBPA disclosures, or the Older Workers Benefit Protection Act. Anytime you're laying off more than 1 employee and at least one of the employees being laid off is age 40 or older, you have to provide certain information regarding the persons that are being laid off, including their age, job title, the department they worked in, and then you have to basically provide a document to each of the employees that's age 40 or older, saying, these are the total number of employees that were considered. This is the number of employees over 40 that were selected. And that just sort of describes some of the specific requirements. A couple other things to keep in mind. Consideration periods. This just goes along with the OWBPA requirements. If the employee is age 40 or older, anytime you present them with a release severance agreement, they need to have, if it's only one employee being terminated, if it's not an actual layoff, but just a single termination, 21 days to consider. If it is more than one employee, then that employee needs to have at least 45 days. There are no consideration period requirements for employees under the age of 40. Some employers, or I'd say probably most employers, is just as a matter of practice, grant 7 days or something like that to consider, because traditional contract law principles like duress and some of the things that employee could later argue and say that, well, this wasn't entirely voluntary, or I didn't have a chance to consult a lawyer about this. You can sort of mitigate against that by allowing 7 days. Revocation, if the employee is age 40 or older, after they sign and return the release, they have at least 7 days to revoke it. Not typically ever granted for employees under 40. And just a couple of posters that are helpful. That is that. Yes.
On that last piece, do you guys have a recommendation on like period of time? So we've done rolling layoffs essentially, and it's like over maybe a 3-month period. And if we just taken the first notice and then updated it for the next round, but like, is that even necessary? Can we do a brand new one for that round? Like, what is kind of the best practice on that?
Well, I think the best practice is probably to do a rolling where you're updating it. Because first of all, as a practical matter, the person who receives the notice has a broader group of people to compare themselves against. If you don't do it that way, which I think can still be legal, the problem is that you raised the question about what you knew at the time you did the first layoff. Did you already know you were going to do the second? Were you trying to skirt that requirement so that you could skew the statistics? So I've always, as a practical matter, liked the rolling. I don't know, anyone else have comments if you've done any sort of rolling layoffs, whether you're going back to the notice? There's no magic number, right? So 90 days, I use a 90-day period. I think you could go back as far as 6 months and do a rolling because, from a business planning perspective, maybe that was already in the works. I would still tell you that what we are seeing is still today, and have been for the last 20 years, a high number of age discrimination claims being brought, because the obvious is true. Anytime a company starts doing layoffs, they're maybe reorganizing duties and they're bringing in people, but they're always bringing in people that are younger. And so that causes, I think, why there's the frequency of claims. And of course, defending age claims is fairly hard, both in presenting that case to a jury, because all the jurors themselves are employees that are getting older and realize that they're going to eventually be victimized too. So that's why I like to continue to go whenever you do a layoff and you give people releases and severance agreements, that you do a look back, gives them a bigger universe of people to compare.
And do you guys go back and give the first rounds the updated one? Or
No.
Okay.
No, that's sort of water under the bridge at that point.
Okay.
All right, well, we're going to talk now about the Colorado Anti-Discrimination Act. By way of background, you may remember that this statute was amended, and it was a big amendment. At the time, we, as the talking heads in the space would tell you, we are going to see a lot more of these cases in state district court. That did, in fact, happen. The pre-amendment of Colorado's Anti-Discrimination Act, the remedies were so limited that most plaintiffs' lawyers in our space simply went to federal court and filed under Title VII. When the legislature effectively made Title VII the same as the Colorado Anti-Discrimination Act, what we saw is plaintiffs deciding, well, let me go to state court, file a claim. The benefit to plaintiffs in state court in Colorado remains largely the same today as it did a long time ago when the statute was amended. Our state district court judges and this is a broad brush, and, not meant to be offensive, but we're never really known to be the highest quality legal thinkers. They're incredibly busy. Their dockets are tremendously overpacked. That remains true today. We don't have enough judges. Whereas in federal court, our federal court judges all have multiple permanent employed clerks to help them with their docket, and they were able to progressively go through them. Our federal judges are really appointed for life, absent some impeachment requirements, and they were really thought to be better legal minds. And so Colorado at one time was one of the best states in the union to do business because you could actually get a case dismissed on what is known as summary judgment. And that's a place in the legal proceeding where the judge says, I'm just going to look at this as a matter of law. I'm going to take the facts that are undisputed, apply that to the law, and there's no reason to give it to a jury because no reasonable jury would disagree. The court can dismiss the case. Today, we see far less cases going to federal court. Rather, they go to state court because judges don't have the time to really give the analytical thought to the summary judgment. And the statistics have proven out that you almost never win at that phase of litigation in state court. And so when the state legislature did this, that's what happened. Now we've had some additional amendments to the statute that I think are important to talk about. Colorado's statute applies to all employers. You employ one person or more, and so that is a big deal. It is a statute that specifically lists sexual orientation as a protected status. Remember, Title VII was only recently found to apply to sexual orientation by the Supreme Court in interpreting Title VII, which was long overdue, frankly, but Congress was never able to actually amend Title VII to have it specifically protect that. Both Title VII and Colorado require exhaustion of administrative remedies, and that prior amendment that I talked about amplified the remedies available to the employees so that they mimicked Title VII to a large degree. But we now have had some changes that took effect this past August. It extends the statute of limitations in Colorado. There had always been some confusion because Colorado had a 6-month statute of limitation, 180 days from the act of discrimination to the filing of the charge. And then if you did not do that, you couldn't exhaust your administrative remedies. You wouldn't have a remedy under the Colorado Anti-Discrimination Act. Whereas Title VII, because we are dual filing jurisdiction, which means when you file with the EEOC, it's deemed filed with the CCRD. Now, who investigates it is dependent on a work share arrangement between the Colorado Department of Labor and the EEOC. So sometimes, 1 year it'll be the Colorado Civil Rights Commission investigating an ADA claim, and 3 years later, all of a sudden that same claim is investigated by the EEOC. But we are a dual filing jurisdiction. So because Title VII said in dual filing jurisdictions you had 300 days to file a charge, our legislature extended that time from 6 months to 300 days. So the same exact statute will apply. I think that's probably, as a practical matter, fine, because simply because you didn't file in state court or under the state statute didn't mean you still didn't have a remedy available under Title VII. So as a practical matter, it just meant that you would end up in federal court. Now, probably even less cases will end up in federal court because of that time frame. Another change by this statute was the extension of the investigative jurisdictional period of time. I will tell you, I'm not sure this, as a practical matter, will change how we deal with charges. My advice to you is to understand that time is always on the employer's side. So allowing the agency to investigate the charge, whether it takes 270 days or 450 days, is not going to harm you. And that's because employees have a duty to mitigate their losses. And so you would expect, especially in a tight labor market, that an employee who was let go by you and claims discrimination should be able to find replacement employment over a relative short period of time. Obviously, there are the malinger types that don't go out and do that. But for the most part, we should see a claimant easily able to find replacement employment, that reduces the monetary incentive to sue you, because obviously they're entitled by remedy to back pay, front pay if they've not replaced their employment, and then, the ancillary compensatory losses that are available. The big thing that I thought was a change in the statute that I should note is in age discrimination suits, you can not only get your compensatory, your wage loss, you can also get punitive damages for a willful violation and that can be significant, especially in an age claim. As I mentioned to you, the statistics show jurors tend to favor age plaintiffs over in race, national origin, or even sex. So that was a big change in there. I'm not sure why. I was chatting earlier with a colleague about this change. It expands the definition of employee to include domestic service workers. So, if you employed a nanny, that person was always really considered your employee. That's why, people got in trouble when they hired nannies and paid cash and didn't take taxes out and pay unemployment, those sorts of things. So I don't know while it was a big change, but it specifically was a change in this statute, probably as a compromise with the more conservative folks in our legislature. While it expands the definition of employee to specifically include domestic workers, it then allowed you to consider sex in the hiring of them. So if you have two children who are female and you wanted a female nanny, you could do that and not get yourself in trouble. So most likely a compromise that I don't have any other specific knowledge about. Some other changes, not with respect to the Colorado Anti-Discrimination Act, but with respect to the Whistleblower Protection Health and Safety Acts. You may remember that this statute, known as FEW, was adopted after COVID. And unfortunately, even though COVID is sort of winding its way down, it no longer is going to be specific to that. Now, we all had a duty under our federal regulatory guidance to provide a safe work environment. You had a duty under the common law to provide your employees a safe work environment. And so, to some degree, an employee who complained about the lack of safety, it depends on what their complaint specifically was, had a public policy protection against retaliation already in the common law. Now we're going to have a statutory whistleblower protection because the FEW was amended here to allow employees who voice a reasonable concern about workplace health or safety, regardless of whether it's related to the public health emergency. So that's how this whistleblower statute now is codified to protect anything that's reasonably related to workplace safety. We will and have seen a number of these lawsuits, by the way, where an employee had come in and said, your COVID policies aren't protecting me, so I don't want to come to work. Those were the classic claims. I've had cases like this where, for example, an employee who was a truck driver but was required to be paired with a peer in the truck claimed after he was terminated that he was complaining about having to ride with this guy, and that guy would stop and smoke, and he was a chain smoker, and then he would get back into the car, and because of the fumes, he claimed he would have had a secondary injury and filed an OSHA claim on it. But under this statute, he would have been able to do the exact same thing. So it's a reasonable health and safety concern. What's reasonable? That's anyone's guess. It's going to be highly fact-specific, case-specific, what the complaint is. I think you'll see an adoption of probably similar to what is adopted in the sexual harassment context, where you're looking at what constitutes hostility. Would a reasonable person in that same similar circumstance feel the conduct was offensive? You've heard that sort of standard in Title VII. I bet you this is what will happen here. Of course, our legislature did not want to define what's reasonable, probably because they're not reasonable, but they want to allow the courts to take their time litigating these issues out. We have not gotten guidance from the CDLE. If I were to give some thought to it, I'm guessing we will get specific guidance. As I mentioned earlier, the Colorado Department of Labor has been pretty robust in getting out in the forefront and being more involved, more so than ever before. I mean, in the last 5 years, we've seen guidance coming from them that we've never seen before on a variety of different issues. Comps orders, by example, those of you who remember the wage Act orders, those are pretty small. Now these comps orders are robust in their analysis. You've seen that the division want to take more power, more investigatory power, the ability to sue on behalf of aggrieved employees. We never saw that before. So we'll get guidance here on this, and I bet you the guidance will be similar to what we've seen in other statutes where the division will take a role in protecting employees and litigating against employers if it decides to be. But I think, consider complaints broadly as to whether that's something an employee has a right to do, and make sure that there's some process by which you analyze the complaint and take that into consideration. Let's talk about, still what I consider to be important today. A lot of you have probably gone through this already and you're over it. I think it's probably here to stay at some level. Vaccinations are and with the prospect that boosters are going to always be here and something we're going to have to do more often, you might see employer policies become more broadly requiring such things as a mandatory flu vaccination. Because if we're trying to be safe, now I don't want to digress into a political dialogue over this. It's hotly contested. But the bottom line is, as a private employer, you have the right to regulate your workspace. I've seen a lot of my clients initially pushing back, then deciding we're just going to accept that this is the world we're in, and so we're going to manage to the least common denominator and mandate vaccinations, and we're going to define that as a double vax plus a booster or a double vax plus 2 boosters. And then, as you saw, some rebellion by employees, and, frankly, it was difficult to replace people. You couldn't get them back in the workplace. I've seen companies now change those policies back and say fully vaccinated to us is just the 2 shots plus a booster. You don't have to do 2. So I don't know where you're at on this, but as long as you have a consistently enforced policy with respect to vaccinations, you're okay. And one that allows for an evaluation of what's a reasonable enforcement limitation, like a religious or disability-based exemption. We still have a number of pending lawsuits for clients in this area, largely in the failure to accommodate under the ADA, very few under the religious exemption. The big question under the religious exemption was that and this has always really been the case for religious exemptions. You just didn't have a lot of employees that were smart enough to assert them. But in the vaccination area, we saw people coming and say, I espouse this belief, and that's my heartfelt religious belief. And, if a client would call and say, are you kidding me? That's really not heartfelt, especially from this clown. Here's the story. But the truth be told, it's so broad that you almost better off just saying, okay, whatever, that's your religion, I'm not going to fight it. But we are still having a few lawsuits there. So just best practices, when you hear the things that a lot of us heard, documentation, you want to give that certainly. Documentation is important because it is the foundation of that interactive process that we all talk about in the ADA context, that you really gave consideration to what the reason the person didn't want to comply with the policy. We might, we attempted to do some form of accommodation, et cetera. So all important. For a lot of us, we just gave in and let people work from home, even though that, as a practical matter, we wanted them in the office. So we'll see how this all plays out. I think we're all evolving. Certainly my office is still evolving. We'd like to get people back into the office, but we're not quite there yet. All right, so you're going to laugh when I say this. The CDC's guidance, was all over the place all the time, ever changing. It seems like it still is. But there has to be some source of what we're relying upon that's reasonably scientifically based. So we continue to look to the CDC for purposes of kind of deciding what was appropriate for vaccination. Again, I said document the file, certainly, but also not hesitating to ask for documentation depending on what the issue was. If it was, I don't want to get the COVID vaccine because, it's not healthy for me. I have these secondary conditions and vaccinations are bad for me. So getting reasonable documentation to support that. Obviously, we have the right and can still consider the effects on other employees in terms of what we do with employees and whether we grant exemptions. And it's important to note that the undue burden direct safety threat assessment is still important in the COVID world, right? We could easily say that was a direct threat without much other anecdotal data being necessary. Maybe changing today because, of course, now with vaccinations, the scientific data out there suggests that people don't get as sick if they get COVID, right? So we're not seeing the death rates as we once did. I mentioned in the religious context, you can look to the EOC guidance on this issue. There has been a number of pronouncements in that area in terms of what they wanted us to do. I think it tended to conflict, in my view, with the guidance we were getting from the government generally about vaccinations and the importance and masking and all those rules that the CDC was putting out, and this notion that, we should impose that on our employees, and then the EOC saying, no, you have to really give in to their secular beliefs or their disability issues. So nothing really different here. Just remember that, political or the moral perspectives were never protected perspectives. It was just always difficult to separate the reasoning behind people's objection to vaccinations generally. Let's skip through that. So let's jump over to wage and hour if you don't have any additional questions there. We are, and we have seen for years, collective actions being a big issue for employers. Collective actions, as you know, is another word for a class action, but in a wage and hour context, because the certification rules are different than a traditional Rule 23 class, which is the kind of class you probably all have been a member of, where you got that little notice in the mail saying, if you want to be out of this, you can sign this card and send it back to us. If you don't, throw it away and you'll be part of the class, and then you get a check for $1.22. It says the lawyer's got $1 million. That's a Rule 23 class. Wage and hour class actions are slightly different, but we've seen these are big payout types of cases for employers. You see a lot of them in the coasts. So if you have a multi-state operation, you do have venue jurisdiction shopping with respect to collective actions. We've seen a lot in Colorado, and I think we're going to see a lot more because, what was an employer-friendly sort of wage and hour structure in terms of exemptions and, who was exempt, non-exempt, what their entitlement to overtime. Remember, Colorado is 12 hours in a day. They're entitled to overtime as opposed to the 40-hour work week. So we never saw a lot of action in Colorado for misclassification, but we will see that in the future. And that's because two things have happened that the Colorado Division of Employment has said, no longer are we just deferring to the FLSA, and that's going to be our legal framework. The division set up its own exemptions. So you had those industry-specific exemptions under the former iteration of regulation. Now with the comps order, a lot of them mimic, to a large degree, the federal exemptions. So executive management level exemptions are you can exempt them, provided you meet a duties test and a salary basis test under federal law. And the state is almost the same, except that it changed its definition. So, for example, administrative exemption, 50% or more of their duties have to be exempt duties, right? That's not in the federal law. What it says in the federal law is that their primary duty is performing exempt responsibilities. So think about it. Colorado says you have to spend 50% of your time or more performing exempt duties. Federal law says that, we're not going to do a percentage test. It's their primary duty, right? So there are cases where a person spends 90% of their time doing non-exempt responsibilities and 10% of their time doing exempt responsibilities, and the court said, oh, they're exempt. Not so in Colorado. So we have seen some modified changes. There was a law this year, takes effect, it was signed into law, I think in July by the governor, takes effect on January 1 of 2023, where under the Colorado Wage Act, an employee can bring a collective action of groups of similarly situated people. Okay, this is important. It had some additional changes where you get under, as you know, the Colorado Wage Act has its own unique penalties that are, statutory-based penalties. So under the Fair Labor Standards Act, if you misclassified an employee as exempt and they really should have been non-exempt and they sued you, let's just say it's a single plaintiff case, the penalties were pretty straightforward, right? They're entitled to their whatever their overtime pay was, because typically it's an overtime claim. And so they would get their overtime damages liquidated as a penalty. Liquidated meant a doubling. If it was a willful, wanton, lack of good faith case, the statute of limitations went from 2 years to 3 years. Okay. Under Colorado law, the penalties are the greater of a 200% of the unpaid wages or $1,000. That's a significant sum of money, because in a single plaintiff overtime case, the damages are fairly small typically. So if you had a misclassification case, like I gave you as an example, single plaintiff, and they worked an average of 45 hours a week, you didn't pay them overtime. It's easy to go back as a matter of your payroll record, especially if you kept decent timing records. That's always a question in these cases, but if you could somehow go back and calculate, it's only 5 hours a week at time and a half. So it's a finite amount of number. Of course, if you violated the law willfully, which often was the case, then you're subject to a liquidated penalty. But this is much more dangerous in my view, because of the way they've set up the statutory penalties. The reason I say you're going to see a lot more Wage Act claims is because of the ability now to do it as a collective action under state law, and you get attorney's fees under state law. So because our wage comps orders now go in specifically in detail how to classify someone exempt or non-exempt, and it's no longer specific to industry the way it was before, we're going to see collective actions all over the place. We've seen a ton of them. One development that is really good is that there's a plaintiff's firm in town that has made it a specialty of bringing cases under the Colorado Minimum Wage Act. The theory being, if you've misclassified someone and you didn't pay them overtime, that you didn't pay them the minimum wage for the hours that you otherwise should have been paying them, right? So the minimum wage is, specific. It's constitutional amendment in Colorado. It's 15 and some change now, 1523 or 1502, or somewhere in there. But the theory was that under the Colorado Minimum Wage Act, you could bring a failure, an exemption problem. It hasn't been formalized by the Colorado Supreme Court, which is really the determinative body that we want. But recently, 2 federal magistrate judges, in one case that I'm handling and another case about 6 months ago, and I swear that magistrate took my briefs, but they found that misclassification cases can only be brought under the Colorado Wage Claim Act, not under the Colorado Minimum Wage Act. Why is that important? If you can bring a claim under the Colorado Minimum Wage Act, the statute of limitations is 6 years. And under the Wage Claim Act, it's the 2-3-year statute that you saw under the Fair Labor Standards Act. I will tell you that there once upon a time was guidance from the Colorado Department of Labor saying we're mimicking the FLSA. Unfortunately, when the Wage Claim Act was adopted by the state legislature, typically when you are adopting a law, you give public comment, you have hearings, people come and testify, there's debate. Colorado was really behind times, and so you didn't have a lot of recordings of the intent of the legislature. My theory was always that misclassification cases should be under the Wage Claim Act, not under the Minimum Wage Act, because if you're mimicking the FLSA, it was that 2-year, 3-year statute. Plus, the CDLE says you have a 3-year record keeper requirement of wage records. So why else would you have a 6-year statute? So we got a court to agree with us on this issue just this last month. It's the second court that has adopted the same theoretical argument. We've had a couple of state district court judges come down the same way. The CDLE won't take a legal position on it because they're waiting for the courts to decide it. The state legislature won't either, for the same reasons I said earlier. They're not going to want to get involved here. So we'll see if those stick, but I think they will. But expect that you're going to see some collective actions under the State Wage and Claim Act. Specific in this amendment to the law, failure to pay is a per se willful violation if you had a prior failure to pay compensation of the same or similar type within a 5-year period. So that's a different standard than what's willful and wanton under the Fair Labor Standards Act. Far easier to get, and note that it goes back 5 years. And so, again, you always want to make sure you're keeping records of any type of Wage Claim Act theory that you've either settled or not. Some new requirements for deductions. Used to be you could deduct wages upon, the failure of an employee to return property as long as you had an agreement, with the employee in advance. So oftentimes when we would put in our handbook, you agree, we can withhold that in your final paycheck if you don't return your property. Now you have this additional obligation within 10 calendar days after. You have to essentially give an itemized accounting of that. And then if the employee returns the property, you have 14 days to return the money. That's a little bit of a change. Again, I do think we're going to see a continued strengthening of the division's enforcement power on all fronts. Much more activity from them in a lot of different areas. This particular change to the statute obviously strengthened their enforcement of the sections 9 and 10 of the Wage Claim Act, especially the Wage Claim Anti-Retaliation policies, expands the enforcement power of the AG's office. I mean, if you've seen some ads by Phil Weiser, all the things that he's done, all of these employee rights, there's a whole number of them listed there. It's all about his rights campaign, but this is consistent with that perspective. We're going to see a much more involved state than we've ever seen before. So audits from the state division far more likely now with these changes on these fronts. Just the other day, President Biden announced that DOL would modify its regulations, and we expect to see, them come out. The bigger one that has come out here is changes to the gig worker and whether you can classify someone as an independent contractor or not. I remember legislation in the 80s being proposed by John Kerry, who was a senator at that time, trying to essentially eliminate employers' use of independent contractors. So it's been around for a long, long time. The government doesn't want us to have independent contractors. But yesterday we had DOL issuing proposed rules, changing the test for distinguishing independent contractors from employees, making it much more harder for us to classify them. Remember, there are a variety of different standards and tests. The IRS has a standard. The Colorado Division of Labor has a standard, which, by the way, is far more like the new federal regulations. And then, of course, federal DOL had its own standard. So if you once could get audited by the federal DOL and win, get the same audit by the state DOL and lose because of the different standards. But it is the multi-factored standard will go out in favor of the economic realities test, which is where Colorado has been for a while. The relevant factors of which are because the 10th Circuit has used that economic realities test, these are sort of the more important ones. But this one here probably it remains, I think, important. I always look to see, is the person economically dependent on you, even if they've gone through all the bells and whistles to establish their own company and they have business cards and they're out marketing in the community. If they're solely economically reliant on you for all their work, they're probably an employee under the economic realities test. I think that's the way our state DOL would come down, and certainly now with these new regulations. So like Uber and Lyft, I mean, what are they going to do under these new tests? They're probably going to change. It'd be more expensive for us to get a ride because these people will be employees. But any changes by DOL will be tied up in litigation. As you know, at least on this stage, the business lobby is fairly strong. And with Biden only having 2 more years, this will be tied up in litigation, even if they're adopted by the department. I would guess until after the next election, which then we're going to see if someone else comes in and the pendulum has to go back to the right, it'll go to the right, and all this will be thrown out, and we start over. So with that, I'll conclude with that and welcome any questions on my updates or anything you want to talk about with David.
With minimum wage changing in 2023 for Denver to $17.29 and then outside of Denver $13.64, one would hypothesize that an employee could just change their address to a family member where they don't actually reside to Denver to get that boost or increase. Can we require some sort of bill that shows their name and it going to that address that they submit in Workday?
Yeah, I don't think there would be any reason why you couldn't require that. The question I would have is I looked at that municipal ordinance, and I think the work has to be performed within the city. And so whether they live in the city or not isn't the telltale test of their entitlement to that minimum wage. It's that the work is actually performed here. So if your office is in Jefferson County, you're okay, right? You're outside the city of Denver. But if you're in the city, yeah, you've got to deal with the multi-tiered minimum wage.
Yeah.
Yeah.
Because with the remote work, it's just where are you doing the work, but then how can we make sure that it's not a falsified address?
So great point. When I was talking to you, I wasn't thinking of that particular scenario. Yeah, I mean, that obviously poses a problem. And with remote work here to stay, I would venture all of us, we're going to have some ability of our employees to work remotely multiple days a week now. I think a reasonable policy amendment that says you need to provide a bill or some evidence that's your primary residence is sufficient. I think beyond that, you get into sticky waters, right? So I think you just go through that minimum. You're going to catch, all the players that are doing it the right way. You're not going to have any problem with them. You're going to catch a few people, but the ones that are intent on being frauds, you got to get rid of them another way.
Yeah. Okay, thanks.
Anything else? All right, we have a short break. There's 2 restrooms over here on the right side, around that corner, and then we'll reconvene here at 10 o'clock.
I think we're ready to jump into our next topic. I introduced myself earlier, but I don't know if everyone was here. My name is Mark Waletsky, and I'm currently the head of our firm's labor and employment practice group. I've been practicing labor and employment law now for about 25 years. And I will say this is one of the things that I have missed during the COVID era. Just seeing all of you in person, talking to you. It was great to do the webinars. I'm not dinging the webinars, but having you all here in person is just fantastic. So thank you so much. We're happy to be doing this and have you here again. And I want to introduce you to my colleague, Juan Obregon. Juan is fantastic. Juan, do you want to introduce yourself?
Yeah. I'm Juan Obregon. I'm a labor and employment lawyer here at Holland and Hart, based out of the Denver office. I work closely with Mark and some of our other partners. I've been a labor and employment lawyer for about 6 years and did some other defense litigation before that. I was a maritime lawyer. I came from New Orleans, and then for a time, so it's a little bit different. But have been doing labor and employment since, and I love it. And I'm happy to be here with you all.
We were thrilled when Juan joined us, and I think as Steve mentioned, if you have any questions during the presentation, feel free to ask. If there are maritime law questions, one to Juan.
It's been a long time, but also
You would know more than me. So today, Juan and I are going to talk to you about non-compete agreements, restrictive covenants. I know that not everyone uses these, or not everyone uses them all the time, but there have been some very significant changes. And so we want to talk to you about kind of where the law was for many years in Colorado on this, because a number of you may have some type of restrictive covenant template in place, and it may have been perfectly good for many years, right up until August of this year, and no longer any good. So we may need to revisit that. We'll talk to you about the changes in the law, and they are significant. As Steve mentioned earlier, Colorado is definitely trending into more employee-friendly laws and interpretations of its laws. And Josh is going to talk about that with respect to the pay equity, and we're going to talk about it here with respect to the non-compete change, because it is definitely more employee friendly. For those of you who have operations in California, California just doesn't allow non-competes. We're not quite there, but we're an awful lot closer than we were before August. We're going to talk about protecting trade secrets, because a lot of times these restrictive covenants, what folks really want to do is they want to protect the secret sauce, right? They want to protect the trade secrets and proprietary information. You can still do that, and we'll talk about that. And then we'll talk also about some alternatives to non-competes and practical advice for things that you can do in light of the recent changes to the law. So here's kind of the high-level overview of Colorado law pre-August, when the new law went into effect. Colorado has always disfavored non-compete agreements. They've always been allowed, but only in limited circumstances, and they needed to pass basically two tests. One was there had to be a specific exception under the statute in Colorado to have a non-compete. And let me back up for a second, because non-compete agreements, we say that a lot. It can mean more than one thing, right? A non-compete agreement often means when you're finished working, or while you're working for our company or organization, you're not going to go work for another company that competes with us. That's the simplest and most basic definition, right, of a non-compete. Just don't go work for a competitor. But Colorado courts have also interpreted non-solicit agreements to essentially be a non-compete agreement. And when I say non-solicit, that too can mean different things. The courts looked at non-solicitation provisions of customers. They said, look, if you're prevented from going after customers with a new employer, new organization, that has the same effect, essentially, as a non-compete. And so we're going to treat those as one and the same. So courts looked at those things as restrictive covenants a non-solicit or non-compete as preventing an employee from going out and competing with an employer. It had to pass one of the exceptions under the statute. It had to be designed to protect trade secrets. It had to involve management or executive personnel or professional staff to management or executive personnel, had to be involved in the sale of a business, or for physicians, there are special rules. And let me just ask, I wanted to ask this right at the beginning, how many of your organizations use restrictive covenants in some form or another? Okay, so a number of folks. So how many, just out of curiosity, how many folks have ever had the non-compete or restrictive covenant challenged by a current or former employee? So at least a few. These are often, agreements that people, they sign and then they don't look at it again. And then they forget about it either willfully or because they've been with the company a long time. And then when it comes up, it has significant consequences both for your organization and for the individual who signed it, typically because they're leaving your company to go work for your arch nemesis, whoever that is, your big competitor, and it can cause significant anxiety, right? When a key employee especially is going to work for a competitor. But the courts have said in the past in Colorado, you can use them in these narrow circumstances and they have to be reasonable, both in terms of their geographic scope and their duration. That was the general rule. Those were the general parameters. Hey, they're disfavored, but if you can fit it into one of these narrow exceptions and you can show that this is reasonable, then we will enforce it. So it was tough, not impossible. Non-solicitation of employees is kind of separate. That's not considered a non-compete. And so if you tell your employees, hey, when you leave, you can't be involved in soliciting your former peers. We don't want you trying to hire all of our folks away to your new employer. That's not good for us. And I talked to a number of you this morning, especially in today's labor market, where it's so hard to fill positions and turnover is tough and challenging. Having a non-solicitation of employees provision doesn't mean you're always going to take someone to court, but it can be something nice to have in your template so that people aren't rating your employees, say, after you've trained all these folks for a year or two, now they know the market, they know everything, and now they're just going to go, hire one, and then you're going to have a bunch following. You can still have those, but again, harder to enforce, generally speaking, because was the employee really involved in the solicitation? Did someone else, solicit them? Factually, those can just be more challenging cases. But then the law changed. And Juan's going to talk about that.
And not about maritime law, because it's been a minute since we've done that. As Mark mentioned, August 10th of this year, just a couple months ago, this new law went into effect. It's the Restrictive Employment Agreements Act. Naturally, because the law just went into effect a couple months ago, we actually don't have that much guidance in terms of how the law is going to be applied. We have the statute itself, we have the legislative intent and things like that. But in terms of how a court's going to interpret some of these ambiguous provisions, it remains to be seen. So we're going to go over primarily the actual letter of the law, the statute itself, and just talk about some practical implications and strategic points of view based on these changes. There's 4 primary changes in the statute. As Mark mentioned, there was already some narrow exceptions for non-competes in Colorado, and as a matter of law, they're presumed they're void unless you fit into that narrow scope. Well, now they narrowed the already narrow exceptions. So we're going to talk about that. We're also going to talk about the notice requirements. They're very comprehensive and have some time limitations, so we're going to go into that. There's also a penalty provision now that wasn't there before, so that's something to consider both, and whether you would want to use a non-compete or whether you just want to use some type of confidentiality agreement. And then finally, the other significant change is that you can no longer contract around the statute by using some sort of a governing law provision. We'll talk about that. The gist there is that if the employee or the worker primarily lives or works in Colorado, then this statute is gonna apply. Okay, so starting with the exceptions, the non-compete, as Mark mentioned, under the old law, it basically said non-competes are void unless you can fit into these narrow exceptions. The first being the protection of trade secrets, the contract for a sale of a business or the purchase of a business, recovering expenses for education or training, or if you're an executive or management personnel, you can still do a non-compete under those circumstances. The most significant thing, effectively, what they did is they completely struck out the executive and management personnel exception, and they revamped. They narrowed the trade secret exception in a number of ways. Now, effectively, for a non-compete to be valid in Colorado, the employee has to be a highly compensated employee under the wage order, which as it stands, that's $101,250. So there's a salary threshold. That's the first thing. If the employee is not going to make the gross salary, if that employee is not going to meet that threshold, then they can't be subject to a non-compete. And then in addition to that, it can only be for the protection of trade secrets. And that protection, it can't be any broader than reasonably necessary to protect the employer's interest in protecting those trade secrets. So it's a twofold requirement. First, they have to meet the salary threshold. And then second, it's got to be specifically for trade secrets. And as I mentioned, we can no longer rely on the management executive status as one of the exceptions. For non-solicitation of clients, and as Mark already mentioned, there is a distinction naturally between non-solicitation of clients and employees. The statute only addresses the non-solicitation of clients. And in essence, the amendments for that are effectively the same as for the non-compete provision in that it still has to be tied directly to a trade secret protection. The only difference, slight difference, is that instead of the HCE designation, the highly compensated employee threshold of $101,000, for a non-solicitation of clients, it's 60% of that. So unless the employee is making approximately $60,000, then they can't be subject to a non-solicitation of clients.
Let me just add in on the non-solicitation of clients, this new law keeps in place prior case law interpretation on what's reasonable. And one of the things to keep in mind if you have a non-solicitation of clients provision is that if you say to your employee, you can't solicit any of our clients or prospects, and this employee worked in a specific territory and never had access to or contact with 75% of your clients, because that employee was in this particular area, that gives the employee a really good argument to say, this is just unreasonable because I can't move to another state or another area and, deal with clients who I had no contact with. I have no information about them. And they're going to say, there's no way this is designed to protect trade secrets, right? Because it's not narrowly tailored to the clients that I dealt with. So I would keep that in mind if you're looking at your templates, you're looking at your agreements, really think about limiting and narrowing the scope of a non-solicitation of clients to, these are clients with whom the employee had contact, about whom they had access to trade secrets, and we often will say within the last 12 to 24 months preceding their separation. Because if they haven't worked with a client for 5 years, again, it's going to be really hard to say, hey, this non-solicit is really necessary to protect our trade secrets.
That's a really good point. In addition to that, we also have to keep in mind that, as we mentioned earlier, these additional exceptions are still allowed. So, recovering training costs, confidentiality provisions, sale of a business or purchase of a business, those are still allowed. We're talking specifically about the trade secret exception and the exception for executive personnel and management. That's no longer applicable. Turning to the notice requirements, there's 3 critical components to that. And the thing that we have to keep in mind here is that failure to follow these requirements may end up causing the non-compete to be void. So this is critically important. And the 3 components, for the most part, are the timing, the substance of the notice, and the signature requirement. In terms of the timing, the worker must be provided to a prospective worker before the worker accepts the employment offer. Okay, that's fairly straightforward. For a current worker, it must be provided at least 14 days before the earlier of the effective date of the covenant or the effective date of any additional compensation or change in the terms or conditions of employment that provides consideration for the restrictive covenant. So those are the timing requirements. Particularly take note of the 14 days just because that's pretty specific. And Mark, correct me if I'm wrong, but it still holds true that at least in Colorado, continued employment is a form of consideration when you're putting somebody under a restrictive covenant.
Yeah, that's right. The Colorado Supreme Court has held that continued employment is consideration. And so technically speaking, if you're going to have someone sign, some type of new or amended agreement, you don't have to give them something extra. I will say that often when I'm talking to clients, or maybe even the majority of the time, if you're asking someone to sign a new agreement that contains new restrictions, new obligations, tying that to a promotion, a bonus, or a raise tends to be more palatable. Legally, you can do it without, but from a practical perspective and just having the person feel good about, okay, I'm getting something extra in return for this, tying it to something extra can really be helpful.
In addition to the timing, the substantive requirements for the notice, there are no magic words. It just has to be in a separate document from where the covenants lay. So if it's in an employment offer, the notice has to be separate and apart from that, and it's got to be clear and conspicuous language that they would be able to understand. You also have to attach the agreement to the notice. You have to identify the agreement by name and specifically note that the provisions may cause the prospective employer or the employee to have a harder time finding employment as a result of that restrictive covenant. So they have to be on notice on what they're signing. And then finally, you actually have to identify the sections where the restrictive covenant is in the employment agreement.
This is, as you can tell, all designed to make restrictive covenants harder.
Right.
I mean, there's no question that we're going to be seeing litigation in the coming months and years over the adequacy of these notice requirements, There will probably be a shift in certain industries where, executives or others may say, you know what, I'm not signing this. There may be more pushback to where it becomes less common. And if you're an outlier on this in your particular industry, that may impact recruiting. So there's always ebbs and flows with this area with non-competes. But clearly the legislature in Colorado said, we want to make this harder to have restrictive covenants in place. We want to make sure employees know exactly what it is that they're signing. And there's nothing wrong with that. Right? Making sure an employee knows and understands what they're signing is great. And look, we all deal with these contracts and handbooks and these lengthy documents and policies all the time. And so I think we're more accustomed to it. Sometimes employees don't look at this stuff as carefully. I'm sure none of you have experienced having to tell an employee, actually, we have a policy directly on this, right? No one's ever had to do that. We know this sometimes happens. They say, they sign off on the acknowledgement or the contract. It's not necessarily a bad thing to point that out and make sure, here's what you're signing. You know exactly what you're signing. That may, and hopefully will help if you're in a position to enforce and say, you didn't just sign a 10-page lengthy legal document. We specifically pointed out to you what provisions, where this is in the contract, what this is. There is no surprise or mistake here about what you signed. So that's going to help, I think, in terms of enforcement. The hard part is there's a lot more bases upon which someone can challenge these agreements, saying the notice was technically deficient. You didn't say this. It wasn't completely separate. I would say it's a great time to really think about how have you been rolling these out, and if these are important to the organization, making sure you follow those notice requirements to the T. Because I think courts, if there is a technical deficiency, it would not surprise me if a court said, look, the public policy is against these covenants. I'm not going to let you get away with even a technical deficiency here. Yes.
Is there any hope that this notice dance will go away? It's so much fun, trying to woo people right now. And then they get all excited about an offer letter. You're like, wait. And 2 months into this,
It's that, yeah, it's,
thinking of it.
it kind of, ruins the, like you said, hey, we're so excited. But need you to read that. I would be shocked if it went away or was challenged. Change of administration, I don't think is going to change it. It's a law in the books. The federal rules, as Steve was talking about towards the end of his presentation, those get challenged constantly, and then they get pulled back if there's a change in administration between Democrat and Republican. At the state level, we don't see that kind of activity nearly as much, and I'm not aware of any even talk about challenging that. There was a lot of behind the scenes lobbying going on before the bill was passed. But I'd be a little surprised if it was challenged or pulled back. Juan, I don't know if you have different thoughts.
No, I just don't see it going away. I think, as we're trying to implement these new provisions and these new requirements, and we're getting significant pushback, and with being able to bring people in, you really have to take a step back from a strategic standpoint and think about, well, do we really need a non-compete to begin with? Is it really worth it?
I'm with you, but our owner and
sure.
CEO.
Yeah, and that's the conversation, right? I think that's what this notice brings. It's like, look, I understand that you want the non-compete. I understand it's important, but as let's see, as we're going to talk about here in a minute, is that it also comes with risk, right? So the extent that I think that just adds a little bit in the let's not do it bucket because of all the administrative burdens with the notice requirements, the possibility of penalties, right? And I mean, unless you really need it, and Mark is going to talk about it in just a little bit, but there's other ways to protect your stuff.
Yeah, well, and ours is I know you're going to talk about confidentiality agreements. Ours is in context with that, but
Right.
the dance, I haven't had any pushback from applicants, so that's great, and it's also like how I sell it, but
The one other thing I'd say in terms of a potential rollback is the trend is going, Colorado's in the trend, right? There are more jurisdictions, more states that are restricting non-compete agreements or eliminating them.
yeah.
That's the trend right now, rather than easing it up. Because what states have been saying is we want more competition and we think these things stifle competition. So unfortunately, it's hard for, especially in a jurisdiction like ours where non-competes were not favored, but we could use them. Mm-hmm. It's really hard and frankly scary to say, oh, so now I have to let my key employees just jump ship, unless we meet these narrow requirements. But I think, that unfortunately it's here to stay.
Goody.
Well, I think this is one of the reasons that it's worth reconsidering whether you need one in the first place. And I know this is a little bit small, but if you can see it says an employer shall not enter into or present to a worker or prospective worker as a term of employment or attempt to enforce any covenant not to compete that is void under this section. And what I find surprising is it's not just seeking to enforce it, it's even just presenting it, right? And with the potential for a $5,000 penalty per worker, it doesn't sound like much, right? But if you have it in a standard template and you're just, have employees all over the state and you're just pushing through these, invalid non-compete provisions, that could be a problem, right? So that's just something that you have to consider. And, I think the other implication of these penalties is that, there's always the strategy of towing the line of whether the non-compete was going to be enforceable ultimately, right? You put a big non-compete that's got a lot of teeth in it. It sounds really scary. And the idea is on the front end, like, oh man, I can't go, right? It'll prevent people from leaving. And, whether you ever decide to enforce it on the back end, you had that decision. You could make that decision later. You could make the cost benefit analysis, but you can't really toe the line anymore because if you knowingly try to push, an invalid non-compete, that can subject you to penalties. And so there's also like a strategic change there in the sense that you really kind of don't want to toe the line anymore. So it's just something to think about. As I mentioned previously, the fourth and final significant change is that there's a mandatory choice of law, and that is if the employee primarily works or lives in Colorado, then the statute applies. So in terms of a governing loss provision or a forum selection clause or something like that, it's not going to be allowed anymore.
That, by the way, is very significant for anyone who has multi-state operations because I know for a number of clients that are based in Colorado but have employees in multiple jurisdictions, even though Colorado's non-compete statute was narrow, we would require Colorado law and disputes to be litigated here because we felt we had the home court advantage. And we often use that very successfully because having employees in another jurisdiction having to litigate here, there was a significant amount of leverage that you could exert in that circumstance. And so that issue, and California has a very similar rule, by the way. So for folks, if you have employees in California and you require Colorado law for any of your contracts or agreements, California really tamped down on that a few years ago and said, only if they're represented by counsel. Otherwise, it's California law. that's what applies. You can't get around this. And so again, I think we're going to start seeing this with more states so that it's going to limit employers from being able to say, all right, we can avoid this challenge or this limitation by choosing, Texas or, some other state law that is more favorable to us. It's becoming more and more difficult to do that.
So as we've been, there's been a further narrowing of the restrictive covenant statute by tying it to trade secrets. So there's, the big mystery is like, well, do I have a trade secret to begin with? What is a trade secret? And, it's unfortunately a bit of a gray area because, while the Colorado Uniform Trade Secrets Act provides a definition of what a trade secret is, you can see here that the definition is fairly broad, particularly towards the end, which says, or other information relating to any business or profession which is secret and of value. And that's great because it's a catch-all, right? But one of the key issues that arises, right, is, at least I'm dealing with two of them right now, where they're very clear, like, oh no, this took so much time to develop, we spent so much money developing these things, and then I say, okay, that's fine, that's great, that is valuable, but what did you do to keep it secret? Like, well, how did you protect it? Is it password protected? Is there a limited amount of employees that have access to this information? And if anybody can walk through the door and just pick up this information, then we have a problem. So you have to keep in mind that you also, it's got to be valuable, but it's also got to be kept secret. You have to have some reasonable steps to protect it.
Yeah, just to add some examples to that of what we've seen, how this plays out. Most companies think they have trade secrets that are incredibly valuable, right? And that give them an advantage, whether it's pricing, their client list, their CRM database, you name it, there's something out there. What ends up happening, and by the way, just to give an example here, a prototypical trade secret is like the recipe for Coke. The recipe for Coca-Cola, that's a trade secret. Doesn't have to be the recipe for Coke, but that's one where, that's it. Customer lists. Customer lists can be a trade secret. That's absolutely, that is one that gets fought over a lot. Pricing, things like that. In today's social media, digital world, what happens a lot with trade secrets is you'll say, hey, you took my trade secrets. You took all of our, our customer list, and now you have that. And that the identity of those customers is, very valuable. Well, we've had this come up, for example, with folks on LinkedIn, and they'll come back and they'll say, every single one of my customers is connected to me on LinkedIn. In fact, a bunch of them have recommended me, and they've said, hey, I work with this person at this company, and then I recommend them back. So the identity of customers alone is often not the be-all, end-all that it used to be because it's often known or out there. But if you have a customer list plus contact information plus additional notes about, those folks, now you've got something that looks more like a trade secret, because if everyone in the industry is going after these same customers, if it's on LinkedIn, if it's published somewhere, that's really hard to say that's a trade secret, right? But if you've added that additional information that you've taken time to develop, excuse me, all of those additional little touch points that really allow you to say, this helps us in the market. It's not just who the customer is. We're all going after the same customer. But we know when they purchase, we know who their key contacts are, we know what pricing, they'll agree to, we know what discounts, we know when they put things out, for this, that, or the other, and so when they need to order more of our product or services, that's the kind of thing that really will help set you apart in terms of claiming there's a trade secret. The other thing to keep in mind is don't assume that just because you either have a confidentiality policy in your handbook or you have a non-disclosure agreement, that you've done everything that you need to do to protect trade secrets. As Juan said, password protecting, limiting access. Do you have independent contractors or consultants who have access to this? Have they signed some type of agreement? Are documents marked as confidential? There's all kinds of things you can do, and there have been judges in Colorado who have said, look, a template or generic non-disclosure agreement is not enough. It's just not. It should be, but it's not. So I would just urge caution, and we can all become a little complacent with saying, hey, we've got a good NDA in place. We're good. I'd really look at that and look at who has access to this information and really drill down. What is it that's trade secret? Is it the customers? Is it the customer list? Is it our process? And who has access to that information? That will really help you if and when you get into a dispute.
And turning to disputes, to the extent that you do establish that you have a trade secret, that you took all the reasonable steps to keep it protected in secret, these are some potential avenues for prosecuting the misappropriation of trade secrets. You've already likely have heard me mention the Colorado Uniform Trade Secrets Act, that's CUTSA. The Defense Trade Secrets Act, that's really just the federal counterpart for CUTSA. The trade secret definition is a little bit broader for the DTSA, but in reality, the main benefit of this one is if it just provides federal subject matter jurisdiction. So to the extent that you prefer to be in federal court as opposed to state court, you can bring both CUTSA and a DTSA claim together. You can bring them concurrently. There's also civil theft. One of the benefits of civil theft is that in addition to recovering the value of the information that was misappropriated, you also get treble damages. So whatever the value is times 3, that can be a significant leverage point, even just asserting that type of claim in terms of posturing it for settlement, because, I mean, let's be fair, these are expensive cases sometimes to prosecute. You have to get a forensic analyst. You have to get experts to, kind of testify to the fact that what you did to protect it, how they uncovered that, all these things were misappropriated. And particularly for CUTSA, if it was willful, you can get your attorney's fees back, which is significant. And for civil theft, you get treble damages. And so to the extent that you can assert that into a claim, then all of a sudden you have some leverage for settlement, right? So you don't have to go through the entire litigation process. And there is significant risk for the other side, whereas they may want to cut a deal early because that's a significant liability issue for damages, at least. There's also a Computer Fraud and Abuse Act. That's less common. That one's primarily used, at least in a civil context, for computer hacking or the hacking of networks or data. But it's just a little bit less common. Mainly, at least from our practice, we typically see the top 3. CUTSA, DTSA, and civil theft.
Yeah, and I would add the Computer Fraud and Abuse Act can come up if someone's access has been cut off to your system and they find another way in. They have another password, they have an admin password, something like that, where it's truly unauthorized access. It's not as common. These claims, look, it's having a non-compete is nice, right? Because it's easy. You can say, don't go work here. Don't go work at our competitor. And that's nice and clean. These, though, each of these claims can come into play if someone not only is going to work for a competitor, but you think they've taken your stuff. They're going to work for a competitor and they've accessed and downloaded information that they shouldn't have. And in terms of the trade secrets, the misappropriation of trade secrets, I wouldn't underestimate how powerful that can be. There's a case in Colorado where I believe it was a headhunter firm and a recruiting firm, and an employee was laid off, and the employee accessed the employer's database of prospects. And that's kind of the keys to the castle, right? For that industry, you keep those prospects, and it's very important. Didn't download and didn't successfully use that information. There was no dispute. But the access alone was enough to give rise to a misappropriation of trade secrets claim. So, and you might be thinking, well, so big deal. So, okay, they accessed it. They didn't have any damages. Well, the Trade Secrets Act gives you attorney's fees. And so suddenly you've got a bunch of leverage because they spent a couple $1,000s or so on figuring out what happened, who accessed. They knew someone had accessed it, but they didn't know who or when. They had to hire a forensic firm, which they did, and it ended up costing them, a few grand. But that turned into a very, very powerful claim, even though the employee had never actually used the information. And sometimes what these cases are about is sending a message, right, to your other employees. You can't do this. You can't just access our stuff to try to help yourself. Even if you're not successful in using it, you cannot do it. And I can guarantee that case sent a very powerful message to the employees at that company, because something that someone would seemingly say, okay, shoot, I shouldn't have done that, but no big deal, was a major, major deal that was litigated for a number of years. The Defend Trade Secrets Act, as Juan mentioned, that can get you into federal court, and sometimes that's helpful, sometimes it's not. What I would say is I always recommend including the DTSA safe harbor provision in your agreements. And so that safe harbor provision, some of you know what that is, but it's basically a provision in that federal statute that says if you want certain damages or relief, you have to tell people that notwithstanding the non-disclosure agreement, they can go to court if they have an issue, and they can use information in court if done appropriately, and they can talk to their counsel. It's a standard boilerplate blurb. It's 3 sentences, but I always include it just because it gives you one more possible option if there's an issue where you have a key employee or an employee who has taken some very critical or important information and you want leverage. Because as Juan mentioned, one of the important things with a non-compete, it used to just be, it's just kind of leverage. It's a disincentive, right? Someone knows they signed it. They don't know whether it's going to be enforceable, but they signed it, and so hopefully they'll comply. Well, if you send them a letter saying, hey, you violated the Colorado Uniform Trade Secrets Act, you violated the Defend Trade Secrets Act, you've committed civil theft, that tends to get people's attention. And we know it's easy for people to, people don't have to break in and carry out boxes of documents anymore, right? You either got, download and send information to your phone, to a flash drive or a thumb drive. The information is portable, but the forensics are phenomenal. And if someone plugged in a thumb drive right before they were leaving, or better yet, this doesn't happen as often anymore, they emailed a bunch of documents to their personal email, which I see some people nodding. That stuff shows up in those forensic examinations. And I have resolved cases in the blink of an eye when we said, hey, by the way, we noticed that you took an image of our entire CRM database the day you left. That's not okay. And that, tends to get people's attention very, very quickly. Yes.
I just have a question. So these stand without a non-compete,
Yeah, completely independent.
independent, and are not being affected by the watered down illegitimate non-compete.
Not at all, but let me give you a caveat. So I think that one of the arguments people are going to make in response to, for example, a trade secrets misappropriation claim, they're going to say, aha, this is really just a non-compete in disguise. They just don't want me to compete. There's no real trade secrets here. And so they may try to rely on Colorado's public policy, but other than that kind of argument they might make on a public policy ground, there is nothing that's impacted in terms of these statutes with the change in the law on non-competes itself. They're still out there, they're still viable, and they can be very important and critical tools to protecting your information.
So what other layers of protection for trade secrets? I mean, just the act of somebody taking a hard drive and loading down a terabyte of information and from your files and everything, is that, if that, it's password protected, but they have the password doing that. But the act of doing that would be
Totally inappropriate.
totally inappropriate.
Yeah.
Easily.
Yeah, if they're, I mean, when they do those big downloads, it's usually pretty easy to tell. And especially if it's the timing, usually the story that it tells is, okay, so let me get this straight. You interviewed with this other company on, August 1st. That company is a direct competitor, right? Yes. And you accepted the job on August 5th. And on August 6th, you downloaded all of this, the terabyte of information. They might try to argue, oh, I was just using this for my job. It never lines up, right? I mean, if you have that kind of evidence, what often happens, though, in a lot of cases is we don't have the big download. We have people who have critical relationships.
Right.
That's much harder because a relationship is not a trade secret.
Right.
And so those are challenging. Colorado just does not protect those relationships. So you would have to be able to show, even if they didn't download something, that they had access and now we think they're using it. I don't know how many folks have dealt with the inevitable disclosure doctrine from years ago. That was a Coke Pepsi issue where I think it was a Pepsi executive was going to Coke high level, and the company said, there's no way they can go do this job without using our trade secrets. They just can't possibly do it. It will inevitably require them to disclose trade secrets. That theory, while still used sometimes, is very hard. Courts hate it, in my experience. They don't like it. And a lot of times what judges will say is, well, they signed a non-disclosure, right? Do you have any evidence that they've actually violated it? And that can be hard to find. And if you don't have that, sometimes they say, no, come back to me if you have evidence. So if you've got the terabyte download or something like that, even if they had a password, if it's done for an improper purpose, you can have a misappropriation claim. But you still have to be able to prove it.
That's a great question. Actually, I think that transitions well in the fact that those statutes stand alone to non-competes. That's Mark's going to talk about the alternatives to non-competes through other means of not having to comply with the recent amendments.
Yeah. So what I would say about this is consider confidentiality, non-disclosure provisions. Keep in mind that with the new statute, it made clear that general skills and knowledge learned on the job is not something that you can prevent someone from using. So if you haven't updated your confidentiality or non-disclosure agreement in a while, I would consider doing so to make sure it makes it clear. We're not trying to prevent you from using general skills and information, public information. We're limited here. We're talking about specific categories and really call those out. You may have more leeway, as Juan said, on the non-solicitation of clients because the salary threshold is a little bit lower. And so you may have a little bit more leeway on that, on using those. You can consider loyalty bonuses. We put that on there. I would say, this is my least favorite, because once you give the bonus, there's not a whole lot of loyalty left a lot of times, right? So the loyalty bonus only works for so long. Can you do it? Yeah, I think really what I would recommend, and this is something that I worked with clients on, and we've worked with clients on for years, even before the change in the law, is look at who in your organization really needs and qualifies for a non-compete. And it may be no one, but most likely there are probably some managers or executives who might still qualify for that. And then for others who don't, consider a good, solid non-disclosure agreement. Having that in place, and for some organizations, you might not need it. Maybe you're in an organization where that's just not necessary. But maybe it's necessary for a certain level of employee, right? I mean, the big thing that I think caused a number of states to start looking at non-competes a few years ago. I don't know how many of you remember the Jimmy John's case. A few. So Jimmy John's, sandwich maker, was having all of its employees, every single one, sign non-competes. Look, no offense to anyone who loves Jimmy John's or has worked at Jimmy John's, but there's just no legitimate business need to say to someone who's on the line making sandwiches that if you go to Subway, that's going to be a real problem for Jimmy John's, right? Because you know how we make our sandwiches. That's a problem. I mean, you can't do that. And that garnered a lot of attention. That's not the only reason this is happening, but I think it's something that, started this. So be careful and really look at who do we need to sign these types of things.
I think, Ted, another one, there was a case out in New York where somebody tried to prosecute a non-compete that was enforced on their custodians, like the building's custodians. And they were sanctioned for it. I mean,
Right.
you have to be really careful because there's no reason a custodian should be under a non-compete.
And what was likely really going on there is it's a fight for talent, right? I mean, that's probably what was really going on and justifying these agreements from the company standpoint is hiring folks at that level can be hard. There's turnover, training people. It doesn't matter whether it's incredibly skilled or not highly skilled. It can be hard to hire talent and find talent and get them trained up. And, what courts have said and what the DOJ is focused on is when you do that kind of thing, you are diminishing wages because you are artificially preventing people from moving around, and that lowers wages, and they consider that to be a problem. So some practical tips. We've talked about a lot of these. Obviously, look at your templates for sure. To make sure they're compliant, because if you're using an old template, you could easily get yourself into trouble, not just having an invalid non-compete, but potentially, as Juan said, exposing the organization to penalties. Make sure folks who are signing it really meet that salary threshold. If you have folks on the bubble, you're really going to have to think carefully about that and figure out, do we really need it for them or not? As Juan mentioned, make sure you're taking steps to protect your confidential information. And honestly, where I see this a lot is consultants, because consultants will come in, either they don't have a written consulting agreement, and we always recommend having something like that in place, or they don't have a confidentiality clause. And then the employee who signed an agreement and you want to hold them to it will say, this information was out there. Regularly, we had consultants who had access to it, and they had no obligation to maintain confidentiality. So that is often a gap to be aware of. And put a notice template in place. Get it in place, get your notice template so that it tracks with the statute. And then you won't have to think about each time we're doing this, right? We have an appropriate template in place and we know it complies. So there are definite steps you can take. It's a brave new world. I know not every executive team or CEO is going to like this. There's going to be a lot of anxiety about it, but unfortunately, as we said, we think it's here to stay. So with that, are there any questions, maritime or otherwise? All right. Well, thank you all so much for your attention, and I'm going to turn it over now to Josh. Talk about pay equity. All right. Do we have another break?
I think so.
Take a little break.
Yes, we've got another break.
There's a lot of eagerness.
A lot of eagerness for the break, that's right. We'll see you back here shortly.
Have everybody filter back to their seats. My name's Josh
One
Kohler,
picture. Thank you.
attorney here at Holland and Hart.
Excuse me.
No worries. Been here for just over a year now. I've been practicing labor and employment defense for 3 years, general practice for 5. So happy to be here, happy to be presenting with my colleagues, happy to see everybody in person and
He's happy.
Yeah, no, I'm a happy guy. It's nice to see people. It's nice to put faces with names, and I think vice versa too. You know.
See smiles.
See smiles, right? I try to smile with my eyes. If I'm still doing it, just let me know. So today we'll be talking about pay equity, and pay equity to me is much more than just employee A is making X and employee B is making Y. Pay equity to me impacts the entire employment life cycle. So today we'll be starting with a brief overview of the Colorado version of the Equal Pay Act. We'll move into job postings, interviews, making the offer, and finally payout. And that should kind of give you a good overview of where pay impact or pay equity is implicated. So starting with our overview, I think there's 2 primary sources of law here. There's the Federal Equal Pay Act, which has been around forever, and we have the Colorado Wage Equality Regardless of Sex Act as amended in 2021 for the Equal Pay for Equal Work Act, which is a mouthful, and I do not intend on saying that whole law this entire time. So I'll refer to it as the Federal EPA or the Colorado Pay Equity Act, or some variation thereof. You can see that they're largely similar, especially when it comes to employer enterprise coverage. I put an asterisk there next to the federal because the enterprise coverage at the federal EPA follows the FLSA, which has the $500,000 revenue. In Colorado, it's just if you have an employee in Colorado, you're covered. All right, it's pretty straightforward. Justification defenses are also the same. You'll see that the primary difference is under the federal EPA, they have a catch-all that Colorado does not have. And that catch-all being just any differential based on any factor other than sex. So it opens the door to different differentials that may not be enumerated in the statute. While in Colorado, we have 6 enumerated justifications, and those are the 6 you have to work with to justify any sort of pay discrepancy. So I think it's important to note. Finally, on the defenses, I'll note the good faith defense that we'll be talking about a little bit more. It's very important to keep in mind as we go through the employment cycle and how we're treating our employees, how we're doing our pay audits, how we're ensuring compliance with these laws. Damages are the same. One final note about the Colorado pay equity law, which I'm sure you know, is it goes beyond the EPA, in which it is prohibiting employers from asking about prior wage history or compensation. You can't use that information to justify new salaries, nor can you retaliate or discriminate against potential applicants for failing to provide their prior wage information. So we'll move into our first hypothetical here. Hard to read for me. Pam was recently given a substantial raise due to her efforts in securing a large client. Shortly after, Pam told Dwight and insinuated that Dwight is an inferior salesman. Pam's conduct has caused discord amongst the office employees, especially Dwight, and there is talk of a mass exodus unless the employer takes action. Can you terminate Pam? And I will not call on anybody, so think of it to yourself. And if someone wants to answer, feel free, but I promise I will give you my opinion on the next slide.
No, you can't turn
Yeah.
it down.
I would strongly advise caution in this case that terminating or even reprimanding Pam would present a substantial risk. The law here in Colorado, the pay equity law, is very clear about discussion about wages both prior to an employment and during employment. And that comes up frequently, right? We don't want to cause discord amongst employees, but the whole purpose of the Pay Equity Act was to allow employees this information. So very high lawsuit danger. All right. So part 2 of the Equal Pay Act in Colorado has to do with job posting transparency, both internally and externally. As you probably know by now, this was it was a hot button item when this first came out, specifically when it comes to job postings and having to post compensation and benefits in the posting, and then also having to promote promotions internally for any sort of vacancy, new or existing. As far as coverage goes, I think we all know that if you have an employee working out of Colorado, your company is subject to the Colorado Equal Pay Act. Now, there are some exceptions to employer coverage, the first being no employees in Colorado at the time of the hiring or promotion decision, then you're not covered for that hiring or promotion decision, even if you're considering Colorado applicants or ultimately hire someone who would work in Colorado.
I don't know what that means.
Let me explain. So if you're working for Company A and Company A, let's just go back to my example, Dunder Mifflin. Dunder Mifflin is seeking to expand its footprint and identify the Rocky Mountain region as its next territory with a strong preference for Colorado. The company currently has no employees in Colorado and is posting jobs on LinkedIn and other sites reaching Colorado employees. No pay range is given, no employees in Colorado, except that the job can be remote. Okay? That job posting does not need to comply with the Pay Equity Act, because until you have a Colorado employee or employee working out of Colorado, you're not covered. And that exception was very important, I think, for the CDLE to make clear, because they got a lot of pushback, and you may remember a lot of companies posting jobs saying, we are excluding Colorado applicants. That's fine if you don't currently have any Colorado employees, but if you have any employees in Colorado, you're subject to the act, even for remote positions. The second exception is the job posting host sites like LinkedIn, Indeed, Monster, whatever the case. Those sites themselves don't need to comply with the law if they're simply republishing your company's job post. But if they're republishing your company's job post and your post does not comply with the law, you're still liable, even though it's on LinkedIn or whatever the case. Obviously, LinkedIn wouldn't need to comply if they have a Colorado employee and they're posting for their own job on their website. Final note on this is that the out-of-state exception is very narrow that we just talked about. It's only applicable, so if you have a Colorado employee and you're posting for a job that is out of state, so you have multiple offices across the Rocky Mountain region, you're a restaurant chain and you've got Colorado restaurants, you've got a job for an opening up in Kansas. That posting does not need to comply because that is completely out of state work. Right, and the example that the CLE gives is actually waitstaff at restaurant sites in other states. But again, it's narrowly tailored. Err on the side of caution. Contact your trusted legal counsel. So, as we discussed, external disclosing compensation and benefits, the rate of pay or range with general description of benefits or compensation. Key note here is that there can be no open-ended ranges. We've seen the CDLE hit people with citations for adding a plus mark. They'll have a range, 70 to 95,000, but they added a plus mark. That is not compliant. It needs to be a actual and genuine belief to low and high end range. Internally, promotional opportunities, you must make reasonable efforts to announce or post all opportunities for promotions prior to making a decision. This is also a hot topic because you may have an employee who has done so well, you're eyeing this employee for a specific promotion. That's, under most circumstances, a promotional opportunity that needs to be publicized to all employees, even though it arises just for this specific one. But we'll talk about that a little bit more. The definition of promotional opportunities, I think, is important. They exist when an employer has or anticipates a vacancy in an existing or new position. It could be considered promotion for one or more employees in terms of compensation, benefits, status, duties, or access to further advancement. Very broad, covers a lot of different opportunities. But it's not every opportunity. So here's a list of what job changes do and do not trigger the promotion notice. So if you're changing an employee's authority, duties, or opportunities, that's going to trigger the notice requirements, and you're going to need to make that notice available, reasonably available, with enough time for employees to consider and apply for the position. If you're changing a title alone and not in materially changing any duties, supervisory authority, that will not trigger. So for example, if you're doing a reorganization and you just want to call all your employees in a certain department or a certain group a different name, give them a different title, that's not going to trigger this requirement. But if you're changing both title and pay, that's going to trigger this. It's an example given is if you plan to restructure a team and give one employee a supervisory role without a pay increase. This is a higher title and has more authority and is essentially creating a new position. That's a promotional opportunity. So you'll see that these promotional opportunities arise more often than what you would normally think. I think the way I frame this and what might make it easy to capture all these different notice requirements and obligations is breaking it down by your basic job description. So we have a job title, you have your location, your description, qualifications should be on here, but also compensation. And we'll break it down one by one to see what are some of the threshold questions. When is this act triggered? What do we need to do? So in our sample here, we've got our job title, assistant to the regional manager. Our location is going to be Denver, Colorado, and or Scranton, Pennsylvania, but we will consider remote. Description, what you would expect for an assistant to the regional manager. And our compensation is going to be salary dependent on experience and a variety of competitive benefits. So starting off with our job title, some of the threshold questions we need to ask. Again, is this a promotional opportunity? Is this a vacancy to a new or an existing position? Have we changed any titles? Have we changed any roles? Most often the case will be that this is considered a promotional opportunity. So I think that should be our default, unless there is one of three narrow exceptions that we had briefly discussed, and I'm going to get into a little bit more later. So if it is a promotional opportunity, who needs to see it? You need to make this notice available to all employees who could be considered for the promotional opportunity, but you cannot make the determination of if they're qualified. So you can't say, oh, you know, I know Group A will not be qualified, or anybody in Group A will be qualified for this promotion in Group B. It needs to be a very broad notice, and it needs to be provided in a manner that's reasonable for all employees to see it. So the timing of when you need to see it, when, after interviews, before interviews, how long before interviews. I think best practice here, if possible, I know hiring can happen quickly and new roles open up quickly, but best practice is to do this promotional opportunity notice prior to interviews. I think you will not be at significant risk if you start that notice during interviews, depending on the circumstances. The law is only that you need to give the employees sufficient time to consider and apply. They have to have reasonable notice of what's included, what the job is, how to apply, what's the compensation.
Has that changed? Because I thought originally it was, you had to post internally, like right away before you did anything else. So
Right.
they backed up on that?
So I think they backed off a little bit as far as the timing of it. But again, best practice is to still
Still do it.
Yeah.
Yeah.
You don't want to test the waters,
No.
especially with how quickly things change.
Is sufficient time 72 hours, or is that also been changed?
Doesn't matter.
Yeah, I haven't heard the 72-hour rule, but
Okay.
I would imagine
It can be almost within minutes, right? Just so it
sufficient time
goes-
to consider and apply.
Oh, no, I'm sorry. I was talking about the release of the information.
Oh, and what was your question? I'm sorry, now
The sufficient time of having it posted,
Posted.
either internally or externally.
72 hours.
72 hours is what I read as the guideline, but I wasn't sure if that has changed since.
You know, in the last guideline I looked at, I didn't see specifically 72 hours.
Okay.
I think if you saw it in a previous guideline, it'd be a safe bet to follow.
Yeah.
The more time you can give, the better. Essentially, what the CDLE is looking for here is not, oh, I'm making my hiring decision the same day as I'm posting this internally, right?
Yeah.
The the guidance that I read is it needs to be sufficient time prior to the decision,
Okay.
give people enough time. Questions to ask, how it will be posted, if you haven't looked at this, if you have both hybrid work sites, so both employees internally working at the office, employees working remotely, you need to be posting this in a manner that it's going to give both in-house and remote employees access. So whether that's posting on an intranet and on-site, just on-site, depending on how your office is set up. Inline promotions. So for example, if you have a lockstep system where promotions are automatic after certain requirements are met, you have a lead sales manager who will move to the assistant regional manager automatically after, $500,000 in sales is met. That is still considered a promotional opportunity unless, again, the one limited exception here is that the automatic promotion occurs within 1 year and is provided in advance at the time of hiring and writing. There is no blanket exception for inline promotional opportunities. Anytime an employee moves from level 1 to level 2, in most cases, unless you meet the within 1 year exception, they'll be considered a promotional opportunity because as the CDLE sees it, you're creating the level 2 position each time you automatically advance. We talked a little bit earlier about the common issue of when you have an employee who's excelling, and that employee is going to be, you want to give this employee promotion, you want to recognize this employee's hard work, and you want to do so more than just a pay raise. That sort of promotion is going to create a promotional opportunity that's going to require notice to all the other employees, which kind of can create a little bit of havoc when you have the one employee you want. Obviously, the decision may or may not be made, but the notice still needs to go out. It could be as simple as Jane Doe is recommended for a promotion to senior accountant, salary 50 to 70,000, health insurance, 401k. Anybody interested in this or similar opportunity can email HR at whatever email address, right? That gives the information that's necessary and also gives the proper notice for this promotional opportunity. So moving on. The location is going to be hiring in Denver or Scranton, or Denver and Scranton. Is this required to comply with the pay equity law? Seeing some nods, and that's right. So anytime you're going to reach a Colorado employee and you already have a Colorado employee, you need to comply. Even if no location is specified, even if it's going to be remote work only, the CDLE is taking a very narrow view on this, and you can find decisions in which they have targeted companies who have been excluding Colorado applicants or whatever workaround they're trying to do. The out-of-state exception is very narrow. Remote work or no location specified is within the Pay Equity Act. Real quick note about qualifications and job descriptions. This pay equity law does not necessarily impact how you are describing the job or what qualifications are a part of the role. But the employment advice here is to just be mindful of what your job description and job qualifications are, because if you have two different job duties, two different job roles, two different positions with substantially similar duties, those could be considered for your pay equity discrepancy or differential. Even though they're two different roles, if they are substantially similar in what is accomplished and what the employee does, you would need to ensure that the pay disparity, if any, is under one of the 6 enumerated justifications. So the practical tip, review your job descriptions regularly. Anytime you're posting a job, anytime you have a promotional opportunity, make sure that the job descriptions match, they're not overlapping, or even if they overlap, that the pay disparity has been at least analyzed and considered. So moving on in our hypothetical job posting, compensation and benefits, salary dependent on experience, and we offer a variety of competitive benefits. Does anybody see any issues? Yes, a lot? Yes, you guys know what we're talking about here. That's not proper. Nor can you say pay is variable. You must give the range or the actual number, and it has to be a genuine and good faith belief what that range is. You can't just say we have a variety of competitive benefits. These benefits have to be generally described, and the way that is in practice is we have a 401k, we have health insurance, we have PTO, we do paid sick leave, et cetera, et cetera. It needs to just give the employee or the potential applicant enough information to know what sort of benefits are part of this. And this last one, you don't need to include. So if you have a gym membership or things of that nature, those are not necessarily part of it. So we talked a little bit about the exceptions. The first one, and this is the exception to the job notice or promotional opportunity, is the incumbent employee is not aware that he or she will be discharged. This one, thank God, is included and obvious here. Essentially, if you have a need for confidentiality, you have an exiting employee, you're separating, that is involuntary, that's not going to trigger your notice obligations, even if you are disclosing this upcoming termination internally with key stakeholders such as HR, the supervisor, if any. This situation, though, will trigger the job posting notice after that employee is discharged and the position is open up to external and internal candidates. The exception also goes away once that employee knows of the discharge. So once there's no longer any need for confidentiality, then your notice obligations are triggered.
So, sorry,
Yeah.
if you identify the candidate prior to the discharge, do you still have to post?
So if you identify the candidate prior to the discharge, yeah, it's considered a promotional opportunity. So in your hypothetical, have you selected a hire for this position already?
Yeah, like
And
they've cleared contingencies, they're gonna start on a Monday, we're gonna fire this Friday.
Yeah. I mean, under a strict interpretation of this, you're creating you have a promotional opportunity, you've allowed the discharge. I think best practice in that situation would still be to treat it as a promotional opportunity and give the notice once the employee is formally discharged, even though you already have someone selected and maybe an offer. In most circumstances, an offer letter's gone out, I would imagine. Based on just that information, I think that there is some risk there as far as this goes, and especially as far as the narrow circumstances go. Because once that employee is discharged is when that notice obligation triggers, but you already have someone. I'll have to think about that. That's a good question. And one that's actually probably pretty common, right?
Very
I mean, that's how we hire. We hire with,
They say, I don't wanna let this person go.
You don't want gap time.
I have a backfill.
right.
Yeah.
And it's interesting because the guidance here gives examples about when you have situations in which you'll have a temporary or acting person fill that role. And that's fine. You can have a temporary position or temporary person fill the role without having the notice obligations. But as soon as that temporary position, and I think we have it up there, yeah, temporary or acting, that's only up to 6 months and the obligation triggers again. So that's a great question. I think there's a lot of unanswered questions that the guidance may or may not shed more light on. But these nuanced situations are going to continue to be problematic, I think. And again, the third exception that we talked about, the automatic promotion within 1 year, this is the lockstep. The key points here is that no notice is required when the consideration for the promotion is automatic following a trial period of 1 year or less, and the commitment to consider that employee for the promotion is memorialized from the start in writing. So in your offer letter or employment agreement. All right. So we've identified the need for a new position. We've considered whether it's a promotional opportunity. We've posted our notices when they were supposed to be posted or given notices to the employees. Time to start interviewing for the position. Important to note is, can we ask about wage history? But I think everybody was pretty good with this early on. No, you cannot ask about wage history. You can't use wage history to set new or upcoming wages at the new position. And this leads to the next question, is how we handle salary negotiations. Salary negotiations shouldn't be that impacted, except for the fact that you can't say, what are you making now? And in my next hypothetical, you'll see, if you're interviewing for a position and inform the applicant that to remain competitive with the market, you're going to give them a 15% increase on top of what they're currently making. Would that be compliant? No, because now you're relying on past salary history. So best practices here when you're handling salary negotiation or training your managers or interviewers, just make it very clear that seeking past employment, past compensation, past benefits, we're not just talking about the hourly rates or salary. It's inclusive of compensation, including benefits. Not to ask about it, not to inquire about it, not to lead the applicant on into revealing that information. And importantly, if you do happen to ask, you can't discriminate or retaliate against an applicant for not sharing that information. Hypothetical we just did. Again, very high danger. Wages cannot be set based on previous compensation. All right, going through the interview process, we're finally ready to make an offer, except for the hypothetical you gave. This is outside of that scenario. Offer letters are pretty standard, but are largely dependent on the company and how much information you want to include and whether you're going to be including the non-solicitation, non-compete that we had talked about earlier, or if you do that in a separate employment agreement, non-disclosures, confidential information. Just make sure that everything you are putting in your offer letter is compliant with, for example, our new paid sick leave rules, right? As we discussed earlier, the 1 for 30 up to 48. I've had to revise many offer letters that have stated the paid sick leave, but it's been not compliant with what is the basic or minimum that we currently have. At-will disclaimers in everything. Exempt, non-exempt classifications are appropriate in your offer letter. Obviously, in your job descriptions, that alone is not sufficient. We still need to give the pay range. And finally, an integration clause or reference to the written employment agreement if you have one. Again, these are largely dependent on you and your company and who you're hiring and what the position is, but these are good things to keep in mind. Oh, and one other note too, if you were going to have the automatic promotion within 1 year, the exception that we talked about, offer letter is a good spot to memorialize that. All right. So the last topic I have for you today is the pay audit. This is during the employment life cycle, during the employee's tenure. A pay audit is straightforward. I'm sure you've been involved in many, or at least one, hopefully, during your careers. But essentially, it's an internal assessment of divisions, of employees, of processes, of systems, of job descriptions, of compensation, of benefits. It's everything that relates to an employee's employment and really their pay. It has always been important to comply with the Federal Equal Pay Act. It's always been important to ensure that you're remaining competitive. It's even more important now because the Colorado Equal Pay Act specifically says that a pay audit of a workforce in 2 years, 2 years preceding a lawsuit can be evidence of good faith. So it's important to strongly consider these if you haven't done one in a while. If you've heard rumblings or complaints about pay disparity or pay equity, now's a good time to start thinking about whether a pay audit is important. And again, don't forget about inline promotions to be included in your pay audit. So just some general steps and overview of the pay audit. The step one is determining the scope. You want to understand what departments you're looking at, what positions, what locations, what work sites are going to be included in this. You want to understand what laws are implicated, both obviously federal, state, and any local laws that may apply. We had a question earlier, a good question about the Denver minimum wage. So obviously localities are open to increasing the minimum wage, so it's important to keep that in mind. And finally, the privilege. If you're engaging counsel, outside counsel really, you're going to want to get an engagement letter. You're going to want to define that this is going to be as privileged as possible throughout the pay audit. And it's important to note, though, that these privileges are not absolute, especially in a pay audit, depending on what sort of information is going to be provided and to whom. Privilege is not always guaranteed, but efforts should be made to keep the attorney-client privilege. So the audit itself. The audit, as we had talked about, you want to look at your policies, your systems, your records. You want to talk about what training is given to management, what management has been told as far as bonuses, pay increases, how those pay increases come, whether there's anything specific to your company or your industry as far as promotions or pay raises, whether that's length of service, if you're putting more emphasis on years of experience over formal education or vice versa. Anything that, or geography, anything that is going to impact an employee's pay or compensation usually should be included. But most importantly, it's the statistics and data that's going to give you the most objective and neutral idea of any threshold pay disparities. I think that's probably the best place to start because you can see between male and female workers in substantially similar areas what pay disparities are there. And if we see any, what policy systems, records, training, whatever the case may be, what is in place that could possibly justify that pay disparity? And then finally, obviously, manager review and training. Importantly, have the managers been trained on implicit bias? Are managers aware that when they are giving performance reviews, whether that be for raises, that implicit bias can be a part of that or impact their decision-making? Obviously, the compensation system is included in the data. So, when raises are given, when bonuses are given, commissions, if you have a lockstep system, if you have a more subjective approach, all this goes into the audit. It's a very detailed process, but what you want to capture is enough information to take a close look and identify where your risks are. And an audit doesn't necessarily have to be of the entire company. I know a lot of companies would prefer to do limited in scope audits, so where you're targeting specific groups, specific departments. That's a part of determining the scope and where your high-risk groups may be. But after you conduct your audit, you have your findings. This is important too, because if you want to maintain your privilege, you want to identify who part of that team is going to be discussing these findings, how they're going to be analyzed, who they're going to be shared with. So you have who is the audit team who may be working on collecting data, speaking with managers, collecting the necessary information. Then you have the part of the remediation, who is going to be implementing that, who's going to be assessing what the risks are and how we may remediate if necessary. And a part of that is also the risk tolerance. If you've identified some pay disparity, is it sufficient enough for you to go through with the remediation phase? Most often, yes. But it's important to understand what could our liability here, and we could put a number value, right? A pay disparity claim starts with a basic number. X is making Y, B is making X. And then obviously damages and everything else that goes on top. So if you do decide to take remedial actions, you have to decide on what remediation you want to take. And most importantly, best practice is the messaging here. I think when you do a pay audit and you need to take remedial efforts, it can kind of come as a shock to some employees like, wait a second, I'm now going to get an increase that I didn't have before. You don't want to signal non-compliance. So I recommend tying these sort of remedial efforts. Obviously, messaging is very brief. We want to be clear that, hey, we've looked into this as part of our ongoing compliance efforts. It's a part of our annual review. It's part of our restructuring or reorganization. Anything to indicate that this is your effort to ensure that you're remaining competitive and not just, oh, we had a complaint, now we think we're in trouble. So moving forward, after you complete your audit, importantly is transparency.
Question.
Oh, yeah, I'm sorry.
I'm sorry. We have a lot of variable compensation,
Sure.
and so if we have a set group that have the same criteria, but we give them an option of a higher base and a lower commission rate, or take a higher base, opposite. Do we need to document which one they choose?
Absolutely.
How would we handle that?
I would say absolutely. I'd say absolutely document your compensation rates for each employee. A part of this Pay Equity Act that I may not have mentioned earlier is documenting the commission or compensation structure for each employee. Those are records that are required to be maintained by the employer for 2 years after that employment ends. So I hope I answered your question. If it's about documenting, I would say yes, absolutely. Document what employees select as far as their compensation. And that'll help in the audit too, right? If you have maybe certain discrepancies, but it was an employee's choice to take one over the other, that would be important information to have. So transparency moving forward. Get employee feedback. And anonymous feedback. If employees are feeling like they're underpaid or that there is some pay disparity, try to get ahead of that. There's ways for you to, as a part of your organization, internal, messaging, whether you do annual reviews and you just say, hey, how do you feel about pay? How do you feel about compensation? Try to get employee feedback here. Try to get ahead of the problem. Employee feedback. Training is important, so management needs to be recommending raises, or we need to have some objective metrics that are applied uniformly across the board when it comes to bonuses or raises. Obviously, there's a lot of subjective need. It's a subjective approach overall when you have someone evaluating performance, but there needs to be some level of understanding with the employee is, what do I need to do to get this raise or get this bonus? And again, get ahead of any sort of disruption about, I don't know what I needed to do to get this raise or get this bonus, and I'm seeing everybody else excel. I just had a very, I don't want to say big issue, but a similar issue in which an employee was seeing all of her colleagues move up, and there was not consistent messaging between her manager's manager, and then her colleagues in other offices about what it took to get the raise or get the bonus or get the promotion. And obviously, if you don't have that clear guidance, your first thought is, oh, it's because I'm X, Y, or Z. So train your managers on how to be consistent with their messaging, be consistent with company policy on what we look for in raises, what we look for in giving bonuses, whether it's a specific hour requirement or any other sort of benchmarks that you have. And finally, job descriptions. I just can't repeat it enough. Make sure your job descriptions are consistent, clear, and they are conveying what the job entails and giving everybody a good understanding of what the expectations are. And that's it. And my time is a little early. Does anybody have any other questions?
Just curious if with this new remote hybrid work world, are you guys starting to see equity claims from employees who maybe are paid, they do the same job as somebody in the office, but they get to work from home? So maybe they're paid a little bit less. Are you starting to see that come up?
I'd open up to my colleagues if they've seen it. I have not personally seen any pay disparity from remote versus in office. I think that would be a tough call, right? In Colorado, we have the 6 enumerated justifications, and one of them is geographic location, but the 10 of that really is to pay for cost of living differences.
Right.
I don't know, have you seen anything, Lon?
No, but I imagine that there is inherent, I haven't, but I imagine there's inherent value in being able to work remotely, right? If you work downtown, parking is extremely expensive. The commute time, all those things.
Yeah.
Time is money, so I wonder if that would go into the calculus of whether that goes into compensation, but
Yeah, definitely not a foregone conclusion that it's.
certainly, yeah.
Kathy, did you have a question?
Yeah, I did. So I have a smaller company, 25 employees, and so as she mentioned before, we definitely have the replacement before we let the other
Yeah.
person go, because it's.
There's no other way to really do
percentage
it.
of our work, and there's no other way. And there's also typically, clearly, we always promote from within.
Right.
And that is typically a very clear, even to the other employees, and I may be speaking a little out of turn, as to who that person is based on production, time, talent, and, and all of that. So some of these are very difficult to do, and you open Pandora's box when you post it, when you have a clear choice, they know you have a clear choice, and then what happens to the other employee who is just maybe 3 years behind being that position. So this is complicated to me for a smaller company, especially when it's a lot more transparent. I mean.
Yeah, and I think the
As to
timing of it
what's
too.
going on and what the culture is and what it takes to get there, as long as you're transparent with the whys.
Right.
I mean, it just makes it a lot of CYA that is obviously CYA that continues to pummel the same people.
My general thought is I would agree wholeheartely, right? I mean, it is CYA. A lot of this is more difficult and doesn't always consider the more nuanced aspects of running a company and hiring, right? This was the same problem with the Healthy Family Workplaces Act, right? There were so many situations that came up where we're like, wait a sec, this wasn't addressed in any of the guidance or, by the black letter law. I think a lot of this has to do too with your risk tolerance, which are you making the efforts to give the notices when it's clearly mandated under this Part 2 of the Equal Pay Act? Are you making the general effort? Are you going to be targeted by either your employees or the CDLE if you drop the ball? Maybe, but again, there's situations that we maybe balance the risk more in favor of running our operations how we have done so, rather than, this strict, okay, I've got 72 hours at least to post this job notice. I'd always recommend compliance, obviously. The only thing I can think of in the guidance was the Jane Doe example that the CDLE gives, which essentially is we've identified our promotion, right? We've identified our candidate. We're going to do a quick little blurb to all email saying, essentially, we're promoting this person to this position at this amount with these benefits. If you're interested, let me know. And that, according to the CDLE, that satisfies it. And you're right, it's a CLA or CYA, and more administratively a headache. But I think those things that you can do, I think it's worth working into your system, at least for that purpose. And who knows, maybe we'll get better guidance on this. Right? It's always evolving.
True, yeah.
Did I answer?
Yeah,
Okay.
yeah. I mean, it's just, kind of weighing the risk and your culture and how things work and trying to transition towards something that feels so overmanaged.
It's so foreign, right? Especially the internal promotion part. To me, I think it's often overlooked. The decisions or citations that I've read on the CWA's website, I haven't seen anything specific to the internal promotions, but that's not to say that, I didn't read every, all 1,000 of them yet, but I don't know necessarily if it is on the forefront of everybody's mind with everything else going on.
Right. There's a lot of changes.
And there's a lot of changes going on, and this one is completely foreign. I think a lot of people had internal job postings, right? I mean, that was probably pretty common practice, but then obligating, the reasonable effort, making sure every employee is notified, even if it's a lockstep promotion, all these other things tacked on, makes it a little difficult.
Yeah.
So I agree. Seeing no other questions, I think that concludes for the day.